Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
The next search on February 28, 2020, 7:44 p.m. How does the FBI find people? The people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right, welcome back from lunch. I owe everybody an apology. The times I was coming back right as I left, which is no good. No good. I'm sorry. That was my fault. Okay, here we go. All right, getting everything in order. I'm reading my junk mail. This is what nerds do for fun, by the way. So I got my my TV technology magazine. I'm going through all this stuff. I think I need this. Do you think I could convince my wife that I need these for my my YouTube channel? It's about a $30,000 soundboard to run a rock concert. A little bit of overkill, maybe. Anyway, let's see. No sounds. Why is there no sounds? Okay, does anyone... Are you guys playing a joke on me? I have sound. Okay. Who was it? Hands up. Who decided to do this joke? Let's see. Is there no audio? I don't know. Audio should be working now. But we're good. Okay. My son comes in and says, I have sound, so it's working. All right. Let's see. We've got to get a couple feeds in place. Let's put that one up there right now. There we go. We have just a few minutes before court comes back from lunch. I think it's in black right now. All right. Let's see. Tap. Is this thing on, Gene? Yes. That's what I'm doing. They had their system on mute. It sounds good. All right, we're good. Let me get my other feed going. What I do is I like to run 2 or more feeds simultaneously, and I like to sync them up so that if in any moment I can switch from one feed to another in case one drops out. And I've got all the equipment to run. I could have 8 different feeds coming in if I wanted to. But let's see. We are going to get this one squared away. Let's put a different one on there. I'm really excited to hear what the judge has to say about the DV verdicts that he took under advisement. So we've got a few things coming up still that are pretty big for the case, and I'll go through that if we've got a minute to do that. Let's see, no video there yet, so we'll keep that there. Okay, if we've got a minute, we'll do this. The thing that stood out to me, and Mrs. R.A. was talking to me about this a little bit, was we were going through the notes and looking at all the different allegations, the counts that are still in there. So you've got count 2, the false imprisonment, count 5, the battery, count 6 is the negligent infliction of emotional distress, and you've got various. It's split up because some of them apply to Jack and Maya and Kyle, and some of them just apply to Maya, or some just apply to Jack. And we'll go into these. I think Thursday we'll do a video that goes a little bit more into that. Count 8, we've got medical malpractice. Count 10, we've got negligent hiring. Count 14. Let's see. That's the negligent training. Count 18 was a fraud. Count 20, that was out. Count 20 is out. That's the fraudulent concealment of the video, basically. Count 21. Count 21 is what the judge was talking about. This is the intentional infliction of emotional distress. And that goes to, I'm not allowed to read these notes. These are just to refresh my recollection. Thank you, Welsh law student. These notes help me. They have refreshed my recollection. That count 21 goes to the intentional emotional distress, intentional infliction of emotional distress on Beata. And that the judge said today that is the only allegation that would even make a difference at all if whether or not Beata had Munchausen by proxy. If MBP was present, the rest of this trial would still go forward. The only thing that it might play into was that count 21. And to hear the judge say that, and then to hear Mr. Hunter stand up this morning and say, Judge, MBP is our entire case. It's our cornerstone. It's our foundation. Everything we're doing is built on the fact that the Beata had MBP and we treated this appropriately. The judge is saying the only thing that MBP even matters on is count 21. And even that, he could be convinced. So see, Joshua, welcome to the gallery. Welcome. Good to have you here. Thank you so much for joining us as a member. We're about to get back into court. I'm just waiting for video to work a little bit better. Hey. No, it's not today. My son's checking on me to say, are you supposed to be recording another court case? And yes and no. That court actually has today off. That's the trial, the People versus Woodyard in Colorado. That's the police officer charged in the Elijah McClain death. And we are recording that one, posting that on our other channel. We do have another channel. We're just posting that video straight. It's just a Zoom feed, and we're posting it with no commentary. But that's where that's going. But there's no court today or tomorrow, I believe. I've got the next 2 days off on that one. I love when RA looks at family like his hand is in the cookie jar. The family comes in behind me over here. If I look off this direction, that's generally somebody came into my studio. I call it a studio. It's really like a closet. All right, let's get a few things straightened out. Apologize, just trying to get everything in order for the next hour here, or for the next couple hours. Oh, there's a buffer. Who on the internet this afternoon? Oh, that's great question. Well, look at this. Portland Trailblazers TV was first in chat. Let me see if I can put you up on the screen here, Portland Trailblazers. Longtime supporter of the program. Yeah, Portland Trailblazers TV was first in chat this afternoon. The first in chat comes with its own penalty prize punishment. Call it what you will. But either way, it is all yours. Portland Trailblazers TV, the internet ownership, and most importantly, the maintenance of all things IP related are now your responsibility for the rest of the day. So good luck with that. Make sure it keeps working for the rest of us, and make sure you head over to the merch page where you can order for just 50 cents your own certificate commemorating your win. All right. Is Sarah Boone still on for the 30th? I have to check it. I have to check Sarah. First of all, I expect another letter from her any day now. She has been a prolific letter writer. Let me check the court really quickly. We've got about 10 minutes before trial starts again with Maya, so let me see. Orange County court records. There we go. Quick little record search for Sarah. See if we've got any new filings for her. I am not a robot. Oh, now I have to pass the test that only robots can pass. Select all the images with cars. There's one. There's one. There's one. There's one. There's one. They keep putting more images up. Okay, I think I'm good. I passed. First try. All right, Sarah Boone, just to answer your question for you. This is Orange County, Florida, by the way. They have not updated the date. I think it's supposed to be in December. I thought it was supposed to be in December, but it's still showing the 2nd of this month, which is not the case. So we'll have to see if they can update that. But we'll keep our ear to the ground and see what happens. I think it's the end of December. Trial date is set for 11th of December. Status hearing at 10:30. Greeners, thank you. Greeners has all the info on Sarah Boone. Thank you very much. If Sarah Boone writes a letter, Greeners will know about it before Sarah Boone does. Honestly, thank you very much for your timely information on that, Greeners. Snazzy Trinkets Jewelry says, do you feel like Shapiro was baiting Anderson?
Do you feel like Shapiro was baiting Anderson? Had Anderson not objected and crossed her on her notes, the defense could have immediately moved for mistrial. I am not believing the "aw shucks sorry Shapiro" act.
If he was baiting Anderson, this is like next level. This is next level lawyering, and I wouldn't put that past them. I mean, these are top lawyers. These are great legal minds. I do think the defense would like a mistrial. But at the same time, if there's a mistrial, wouldn't the plaintiff then include the SA allegation in their next filing? Don't you think they'd include that include that in the pleading? Wouldn't that be worse for the hospital if it ends up going around again? I don't know. Great idea, Stazzy Trinkets. I'll have to give that some thought. I'll watch for it. If you think he's playing us and them. I think it was an accident. I think, honestly, there have been moments where we have seen a very contrite Mr. Shapiro, where he really, hat in hand, bows before the judge and apologizes. So I think he got carried away. I believe him personally. I believe when he said, I didn't mean to open the door, I believe he did not mean to open that door. That's something they do not want in. They don't even want it talked about in open court. Okay, if they could keep it quiet, the quieter they can keep that, the better. So I don't think on that one personally. That's where I'm leaning anyway. You can convince me otherwise though. Could they sue the hospital again for the SA? Be Kind Tiger, this is a great question because I believe there's an immunity for issues that arise out of the civil suit. I don't think you can sue twice. Like if something comes out in court, you can't file again. And now we're going to sue you again for something in the same incident. There may be an overlap because this is SA, because this is sort of outside that whole treatment, because it wasn't medical, because it wasn't. It may be able to stand alone on its own case, but I don't know. That's something that you'll have to consult with a lawyer, and a very good one on. Based on the other attorney reactions, I don't believe Shapiro did that on purpose. Seriously, did you see Mr. Hunter? Mr. Hunter with oh, why am I here? He's like, he just stared down, throws hands up. He was miserable, the poor man. All right, the feed is getting slow to being reinstated, so give me just a second. We'll get this back up. That's not live yet. Apparently we're just in black. So we'll get some audio here shortly. Okay, Lawn Lumber. Rob says, it wasn't on purpose. I can almost guarantee. Risk is too high for hospital. If judge lets those answers in, hospital is made to be liars, and it's almost a guaranteed verdict. Oh, yeah, and it's like one of those add zeros type verdicts. This is not one they want. Thanks for your take, Rob. Appreciate that. Could she be held liable for not reporting? Elise, I think she already might be stepping in it. This is already. I looked at this and I looked at this and I said, if she really thought this happened at a prior hospital, doesn't she still have the responsibility to ask those additional questions to see if this is the initial time a 10-year-old child is reporting this? If this is the initial time, doesn't she have that additional duty to do a little bit of due diligence on her part and see exactly what happened and if this has already been, taken care of or not? Yes. It is her liability, is her responsibility to report only for things that her own hospital does? I would say no, because look at the whole Munchausen by proxy allegation. They're literally reporting that something outside of the hospital, somebody was harming one of the children. Doesn't she have the same responsibility to report that the hospital felt they had when looking at and not liking what Beata was doing? That to me seems major and a big problem. And I don't know how they're going to handle that. I think we'll see after this case is over. I think the family will probably take action on that, is my gut feel. I don't know what Rob thinks on this one. I do think initially I thought he was going to let it in, but the judge's explanation was right. He reminded me about the problem they have with a jury that was not questioned on SA issues, where they might have jurors who, for one reason or another, would have been stricken for cause from the jury. Okay? Meaning that the court can see that because of the situation, the experience the jury has been through, or what they're doing in job, it could be a million different reasons, that juror would not be eligible to be a juror. And if you suddenly introduce those elements of the case and throw those on the jury and make them decide, it's just it's a blank check for a reversal on the decision. So I think the judge was right in doing this. Obviously the family still has the ability to pursue something along those lines if they want. I don't know how it could happen, but I was hoping that the judge would have come back with something like, we want to be able to, because for me it was more of an issue of impeachment, right? Because this is what they're doing. They're trying to discredit the witness, the psychologist that was up there testifying. What's her name? I have to pull it up again. Just one second. Kastenstein. She's up there testifying. And I thought this would be to discredit her because she literally testified to the opposite just a minute ago. Ooh. Apparently, it's almost time. It's almost time, guys. It's like when they flash the lights in the theater. We're about to begin. I was wondering if there was a way the judge could find a solution that wasn't jury, forget we said that was more in the lines of, yes, she did report something earlier, and I was wrong. If they just got that much in. It was the Poltergeist, says Krista. What was that movie? I think it was called was it The Pulse? Okay, I watched that movie as a kid. There was no way my parents would have ever given me permission to watch this, but I snuck over to a friend's house and watched The Pulse in it was like the friend's grandma's basement, and no one was home, and we snuck in and watched that movie. I still have nightmares about that. It was so bad. Just electricity out to get you. All right. Let's see. Trust the jury to make that inference. The jury is on it. The jury is really on it. Okay, I do have the burner phone plugged in if it's needed. I have not been answering the burner phone number. I believe Rob has my non-burner phone number. so if he wanted to call, I think he's at work, but we might be able to work something out. We could put him on the air. But I'm not, Rob is at work. He has a real job during the day. Witness doctor will know this now. No? We still have the cross for this doctor, Pauline. So she's still on the stand, and we also have jury questions. What was Shapiro's question? Steven Shapiro asked the question where he was asking about Maya and her liking the hospital and liking the playing and physical therapy and the rec room and everything, and he asked a question that says, did Maya ever report any mistreatment by the hospital? That was basically close to what he asked, but it was any mistreatment, and the witness answered and said no, but this witness in her report had that little blurb about the SA incident, and that's what potentially would have opened the door. Yes, Rob is the real lawyer. I just play one on YouTube. I don't even play one. I do not pretend to be a lawyer. I just really, really like true crime. What are the chances that she heard about it during lunch? Hopefully very slim. The witness was given very strict instructions not to talk to anyone, including the lawyers, about her testimony. The witnesses are also under the sequestration order. So unless they are a designated expert witness, they cannot sit in court and listen to other testimony. They can't watch the news media about this. They should not be watching the live stream. That would be very inappropriate. And the judge would have some very stern words to say if that occurred. All right, so we've got one feed. Let me get my second pulled up. There we go. And let me get back into Zoom. The court Zoom has been extremely useful. Really liking that. Okay, the judge is on the bench on the Zoom, so it looks like we're about to begin right now. Let me listen in.
Okay, please be seated, everybody. Let's talk about directed verdict motions and rulings with respect to directed verdict motions first.
Please.
Okay. As it relates to the battery count, which is count 5, and that portion of the battery count that deals with the transport to the EEG room and the time period in the EEG room, I did not see any evidence of a battery occurring during that discrete time period. And so I did see there was clips that were identified, but I did not see a battery occurring in those clips, nor in Maya Kowalski's testimony. And therefore, that portion of count 5 that deals with the EEG transport / in the EEG room, I'm going to grant the directed verdict motion as to that variant, and because I'm directing a verdict as to that portion of count 5, obviously the punitive damage motion with respect to that portion of count 5 will be granted as well. Obviously, this does not impact the false imprisonment claim associated with the 2 days within the EEG room, but that's a different tort than battery. And the other counts, 6C, 14C, and 18, I'm going to go ahead and deny those counts, finding that that the plaintiffs made a prima facie case with respect to those counts. And just to be clear, if I have not already granted a directed verdict on something, just to wipe the slate clean, I will deny as to anything that I have not physically and specifically addressed. Mr. Altenburn.
I just wanted to get clarification. Did you deny the directed verdict on the fraudulent billing claim?
No, on count 18, I am not denying. I am denying it. I am not granting it. I am denying it. So the only one that I granted today was with respect to count 5, that portion dealing with the EEG room transport and during the time in the EEG room and the corresponding punitive damages. Everything else got denied.
And there's 2 punitives in my notes. I'm not sure if you did make rulings or not. I had sort of that you were still.
I'll spell this out for you.
On punitives as to the battery in the chapel area, or did you? No, you might have made a ruling that there were no punitives, but I'm not clear on my own records on it.
The
unwanted
hugs
affection
and kisses / instance, I already granted as it relates to punitive damages.
All right, and
then
on the
I
ICU,
denied it for the photo session, so there will be punitive damages for the battery. And then I just denied it, I just granted it with respect to the EEG room transport. Now, in false imprisonment, I denied the motion for punitive damages as to the EEG room, and so the jury will get punitive damages for false imprisonment associated with the EEG room.
and do they get punitive damages as to the first week in the when we did not release the child from ICU? That was the other one. That was a little one.
I don't think I ruled on that, so I'm going to deny.
So every time the judge says deny, that's bad for the defense.
Okay.
That's bad for the plaintiff. I'm getting you guys confused.
Pivot to your question from this
I'll
morning.
explain this in a second. I'm trying to listen and talk at the same time, and I'm bad. So deny means we're not going to grant a directed verdict.
On
That means it's
the
still going to go to
proposed
the jury.
instructions relative to the time frames and what the dependency court. I've got some thoughts. Either we can do one of two things. I can kind of tell you concepts that I want to see, and then you can do another one, or I can spend some time and try to get something tonight and be able to send it out tomorrow. I can do either of the two.
Whichever you think is, at this point in time, would be more productive is what I'm happy to do.
Well, I also, and then I need to know from the lawyers what I need to rule on tonight. And I will tell you, yesterday I was, I had first appearances, and then I was ruling on a trial from before. So, the 14 hours I spent working yesterday, I did not work on your case yesterday. I worked on it on Saturday, but yesterday I was over at the jail and doing another case. So
this judge is getting the OT.
I don't remember what you need me to rule on next. I saw some things about deposition designations, but then I got emails saying wait, and I haven't followed that.
If I can clarify that for you, Judge. So I believe that was on the Malik deposition, and what occurred is that the plaintiff had sent that to you, inadvertently didn't copy us. We, meanwhile, were getting a deposition highlighted and to send to you. So on the Malik deposition, you should have received this morning a highlighted deposition. And the only thing, we have one objection, I think, that needs to be addressed. And I think there might be 5 or 6 objections from the other side that needs to be addressed so that we can then edit and play that deposition. I don't think it'll take the court that long. The deposition itself has been significantly cut down.
So I need to do Malik tonight. Are there other depots I need to review?
Yes, Judge. Well, we have a deposition issue. The plaintiff is declining to give us their counters or objections to Brandon Alexander Depp. They think that first the court has to rule on the admissibility of the deposition itself. And so I'd like to address that.
When are you trying to play that one?
We're running out of time.
Yeah, we're getting scrunched here, Judge. As soon as we can. I do have the depth so the court can make a preliminary ruling. I don't think it'll take long. I could give it to Your Honor to look at while.
Sure. I'm trying to figure out how much time I need to spend on these other issues tonight so I can answer Mr. Altenberg's question.
The other issue, Judge, is we need rulings on the exhibits that the court took home. Mm-hmm. And we're going to have additional exhibits tomorrow. So we need some rulings on those.
Okay. I don't think the exhibits is going to take me that much longer since we had the discussion this morning. I should be able to, tomorrow morning, just be able to come in and say, X, Y, and Z is in, ABC is out. And I think I can just make an announcement. But I don't think that's going to take me much time tonight.
Okay. All right. And I don't believe we're waiting on cross designations for Dr. Hannah's deposition. And like I said, the Brandon Alexander, I think there's going to have to be a preliminary, apparently, legal argument with court. We could do it perhaps when the jury leaves today. It won't take long, so that they can then get us their cross designations and objections, and we can move forward on that deposition.
Okay, so we will do that when the jury leaves today.
That'd be great.
Even if he gives you the cross designations this afternoon or this evening, I'm probably not getting them tonight anyway.
Understood.
Yeah.
Understood. But we need to get the process moving.
So to answer your question, Mr. Altenberg, why don't I take a draft? Now, what I will be giving is not a ruling,
I understand.
but it's my effort to send this farther along. Now, has Mr. Elegant seen?
Yes, I said that to him actually shortly before I sent it to you on Friday.
Okay.
And I've got nothing yet back from him, but I pinged him this morning that we were going to need to start working hard.
Conceptually, I want to call the actions in the dependency court just the dependency court.
Okay.
I want to try to avoid some of the passive voice.
Okay.
And I want to try to tighten a lot. And well, that's the types of things. I mean, from a content standpoint, I think mostly I'm okay with. There's a lot of instances where we repeatedly say Johns Hopkins is not responsible. Johns Hopkins is not responsible. I'm not going to do it like that.
Okay.
It will probably be more of a statement, at the beginning or the end, but I'm not doing it every other sentence.
Johns Hopkins is not responsible.
But all right.
Well,
Of course,
2 or 3
Mr.
times on the
Altenberg wanted
first
that in.
page.
There's 2 on the first page we can combine for sure.
Okay. So I will do that tonight, and I will get it out to you and Mr. Elegant in the morning sometime.
Hey, Rob, if you're doing a recap tonight, can you put the time?
Anything else on that issue before we go on to another issue?
A lot of people are very interested, myself included.
We'll all have a chance to look at the proposed orders, even as lowly trial counsel.
No. This is appellate lawyers only.
I mean, for the defense argument. They just needed to know that.
Of course. My assistant will be happy to send it to anyone that you all designate. I just assumed that it primarily is a Mr. Altenberg and Mr. Elegant
That is true, Judge.
conversation.
I just want to make sure some of the minutia of the orders gets in. So we'll do it.
They're the designated appellate lawyers. So it's going to be 7 or 8.
Standing, so I guess that means you're next.
Thank you, Your Honor. We've received their witnesses for tomorrow, one of which is Dr. Elliot Crane, who is one of their experts. So I don't know if the court would prefer to do that this evening or tomorrow morning, but we need, at least as to Dr. Crane, a ruling on our motion to limit his testimony to specialization and his report.
Well, that sounds like something we'll do after the jury leaves for the day.
All right, thank you.
Anything else before I bring in the jury, since it's...
Yes, Your Honor. I wanted to, and this is Trial Exhibit 2093-002, if you want to bring it up. Okay. And it's the order of, it's the order of November 10, 2016, this one. And it's specifically... the language on paragraph 6 of page 2, and I can read it to the court, and then Danny's bringing it up. And it says, upon the invitation of the child's treating mental health professionals, the parents and Kyle are authorized to attend therapy and counseling sessions with Maya. And I just don't know how much I'm allowed to use these orders in terms of impeachment or refreshing.
Judge, they're not in
all.
evidence. They're not in evidence.
They're not in evidence, but...
Who's the witness again? Remind me.
Katzenstein, the psychologist.
Was there ever any evidence that they attempted to have a therapy session after that order was entered?
Yes, I mean,
She testified on direct about her effort or lack of effort to facilitate these family therapy sessions.
Here's the thing: we're not we're not talking about the orders. You can ask the question if, she attempted to have a therapy session.
I just, so it's clear, her testimony on the subject was very clear. This order got in her hands somehow, and she went, I showed her the note. She went to risk management and said, what does this mean? I'm not a lawyer. And they told her something to the effect of, the order authorizes family counseling sessions, and she said, I'm not a family counselor, so I can't do these sessions with the family. That's her testimony to this.
Okay. So what's the specific question, Mr.?
I was going to ask her, were you during this period of time the treating mental health professional for Maya Kowalski? And if she says, yes, I am, I'd say, well, you testified on direct about some meetings and counseling sessions with Maya and her family. Did those ever take place? No. And I guess then her response would be, because I'm not a family therapist.
I don't mind you asking the question if that occurred, but let's not talk about the court orders or referencing, well, the court said you could do this, or the court gave you permission.
That's my questions. That's one. And then there's also, I was going to...
Mr. Shapiro, that concept, assuming Mr. Anderson constrains himself to what he just said?
If he's only going to ask her, did you perform any family counseling sessions? And she can repeat what she said to me on direct and why she didn't, because she's not a family counselor. I agree with Your Honor. I don't think you can ask the next question. Well, the order authorizes X, Y, and Z. So I think you just can ask the question. I don't have a problem with the question.
Well, the next one would be, why not? And she would, I guess, say, because I'm a family counselor. And then my question would be, but wouldn't those have to give the opportunity for Beata Kowalski to see Maya?
Well, I don't think that question's allowable.
Okay. Then the next one...
Just think of all this time I'm saving.
I'm learning. It only took me like 3.5 weeks. Then this is Trial Exhibit 2263-001, and it's not for admission. I'm just going to use it to refresh recollection.
Can we see what it is?
It's an email baby to, you know what? Hang on.
What's the number?
It's 2263-001, and what I'm trying to figure out here is whether she has knowledge of this. And yes, she does. So I needed to ask her a question about this. So it's not admitted at this point. I think it's become relevant in the case. If it's not, I'd like to mark it for identification, and then move it in. Try to move it in my rebuttal case.
I don't know how this would be relevant to Dr. Katzenstein. The responsiveness is unfortunately the clinic won't be able to attend.
Yeah, I know, but mine's a little different question.
What are you attempting to ask her about? What are you trying to refresh her recollection?
I'm just trying to refresh her recollection that Sally Smith was on the treatment team.
No. Why?
Well, that is a theory of their case. And this.
So he's going to ask Sally Smith for a legal conclusion on whether Sally Smith was on the treatment team?
I think, he was using this to refresh her recollection if she needed it. And I don't know if she needs it, as to whether Dr. Sally Smith was trying to get a whole bunch of providers together to talk about Maya Kowalski's future care.
Yeah, and I guess, not to turn this into a long didactic lecture, I thought the only thing that we were responsible for Sally Smith for her agency was any treatment that she was giving to Maya in the hospital, right? Not which her function was for this.
That is correct.
So what would this establish?
She's part of the treatment team. It manages all the treatment at the hospital.
That draws the line between her and the hospital.
That one email where Sally Smith would like us to get together is going to establish that Dr. Katzenstein and Dr. Sally Smith was part of the treatment team for the entire hospitalization. Or Kathy B. Or Kathy B.
The answer is this seems highly relevant, Mr. Anderson, and you will be allowed to refresh your recollection if she needs it.
But to be clear, it is not in evidence.
It is not in evidence.
That's why I said to refresh your recollection.
I want to make sure Mr. Anderson heard.
And just so we're clear, do you have this document in paper form so we don't have to worry about me turning off the
Right here.
turn off the public systems and all that and the jury systems?
Until you hopefully will just say yes, Sally Smith was on the team. I won't need to.
Yep.
Can I be heard on this just because I don't, it's got the so Sally Smith's inquiring of people at all children's about Maya's future needs for the purposes of where she's going to go in terms of the dependency action, right? Because that's what it's going
That says as a treatment team.
Right, but it says I'd like to talk to the treatment team to figure out what Maya's future needs are, because Sally Smith's going to take that information and go to Judge Hayworth and say, all children's, per their records, shows that Maya has these treatment needs, so the cross-examination or the redirect I could have is, what do you want me to get into with this witness? All children's doesn't direct the dependency court. Sally Smith's making her own independent.
No.
Does this blow the door wide open, all of this? It seems to me.
Again, the fact that Dr. Sally Smith was involved even before the first call was because she was consulted, right? And there is an allegation here in this complaint that Dr. Sally Smith's actions or inactions constituted medical negligence, and that the hospital is responsible. And what I think the plaintiffs are trying to show is that she's actually part of the dependency team. Now, she's wearing two different hats, I agree with you, but the hat to which she is a provider, to the extent the jury were to find that she were a provider, and I'm not here to say she was or wasn't, that's the jury's decision, that's allowable. On the hat that she is wearing as a investigator for the dependency court, that's not allowed. So this seems to be evidence that would suggest that Dr. Sally Smith was also wearing the hat of medical provider.
But under the statute, Sally Smith is allowed to consult with the medical providers at all children's.
You can keep saying it. We can do this again and again and again, but I think I've been consistent on this issue that to the extent that Sally Smith is providing or appears to be providing medical care and treatment as opposed to beyond her role as a child abuse investigator, it's going to be admissible.
This is a big loss for the defense.
Not the email, but the line of questioning that Mr. Anderson.
Mine's very simple. So it's the final one. I just want to make sure I'm okay on this. This is not in evidence, but it's trial exhibit 2277-253. We've tried to move it in a couple times. I want to use it to refresh your recollection. This has to do with Ms. Beatty. This is Debbie Salisbury's letter of November 18th, 2016, to actually directly to Jennifer Katzenstein, PhD, in which Debbie brings to her attention the fact that there were concerns over Ms. Beatty. So maybe she'll remember it, maybe she won't, but if she doesn't, I wanted to use this to refresh her recollection.
Well, I want to be clear. For refreshing somebody's recollection, if you need to refresh someone's recollection, you can pretty much use anything. But we're not going to members of the jury, I've got this note and show it as to the jury.
This is what Shapiro did.
Pass them to hand it to.
I shall not.
Okay. And we're not going to read from it.
No. It's hard not to use some of the words, but I will not read the sentences.
Judge, more specifically concerning is that he wants to get into what's going on with the attorney for the dependency action, complaining about things happening in the dependency action.
And I don't know what specific questions he is going to ask.
Well, that's what this letter is all about.
The question would be, Dr. Katzenstein, you are aware that questions were raised about Ms. Beatty insisting about being on a lot of these telephone calls and other issues concerning her conduct. Not really. Well, did you receive any writings about that? I can't really remember. Would it refresh your recollection? Yes, it probably would. Here.
I like him doing both voices.
Memory refresh. Now, can you tell us whether you ever received any notification there was a problem with Kathy Beatty? Boom.
From the attorney representing the falsities in the dependency action?
I'm not throwing in the attorney.
But that's who it's from.
That's what's on evidence.
This is not an evidence.
To the extent the witness needs her recollection refreshed, he can use the letter. That does not mean the letter is coming in, nor does it mean he's going to be able to ask specific questions off of this letter.
But
and I anticipate that if there's a question that's objectionable, you're going to object.
But just before we open this, am I allowed to could I redirect Dr. Katzenstein and say the letter complaining, the complaints about Miss Beatty's care were coming from lawyers for the Kowalskis?
Does it matter whether it comes from Mr. Kowalski or the lawyer?
To me, it does.
Why?
Because she's getting a letter from a lawyer complaining about Miss Betty's conduct that were the same complaints that they were bringing to the dependency court.
Based on hearsay.
Based on hearsay. I mean,
I am being asked to rule on hypothetical questions and redirect to questions that have not yet been asked. So it's very difficult to make that ruling. All I'm saying is the witness can be shown this letter to refresh her recollection if necessary. I'm not necessarily saying that the question that he's going to ask is going to be allowed. And this letter obviously is not in evidence, nor do I anticipate it's coming in evidence.
There will be a lot of objections.
Anything else? Or can we bring in the jury? Let's bring in the jury. Let's get the document.
Judge, the letter's still up.
Yeah, let's get the letter down, please.
As they get the jury, the defense throughout the first half of this trial has been laying landmines and rolling out barbed wire around all sorts of different areas across the battlefield. And now they find that they themselves have to cross that same battlefield, and they're tiptoeing through trying to avoid things. And it's some of them are their own traps that they want to get close to and not set off. So it's very delicate tightrope walking here, and sometimes they were too effective at keeping the other side out, and now they can't get their point in without letting something in. So this is going to be interesting to watch. I'm not sure if the judge is going to allow this full line of questioning.
Please be seated, everybody.
But we'll see how far it goes.
Good lunch. I want to confirm that while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And no one approached you about this case. Is that correct? And you did not see any media coverage. Is that correct? Okay. And we're now in cross-examination, and Doctor, you're still under oath.
Thank you. Now, Dr. Katzenstein, you are a PhD, not a medical doctor, correct?
And Katzenstein.
I'm sorry, Katzenstein. Dr. Katzenstein. Reviewing your records, it looks like you just had a couple of actual diagnoses, if I'm correct. And is it true that during this period of time, this 97 days that Maya was there at the hospital, that you were the only therapist working with Maya? Psychological therapist, that is.
Psychological therapist, to my knowledge, yes. There was a music therapist as well.
I understand. But in terms of the psychology of meeting with Maya and trying to work through that, you were the only one?
Yes.
Is that right? And you met with her approximately, 8 times, actually meeting with her?
I think in total, per my notes, 10 times with her.
Okay. But were some of those just for like a minute or two?
No, I have 10 notes with documented time.
Of 20 minutes or 25 minutes, is that right?
Correct, or more.
Okay, one or the other.
20 minutes or more.
Okay, well, it says 20 minutes on all of them, does it not? Specifically, except for one that says 25 minutes.
I have a 35, a 21, a 25, a 25, a 20, 20, 45, plus a 60 initial.
Okay, so you got 60, 45. So all in all, did you ever total up approximately how many hours you had?
I did.
And how many hours?
In total of time that was documented, in which I did not document time on 7 notes, I had 5 hours.
5 hours. And this was over 97 days?
This was over the period of I believe less than that, because I wasn't consulted until the 10th meeting with the family on the 12th.
So, take a week off, maybe 90 days? 3
90
months?
days.
All right. 5 hours. All right. So if the jury were to go back and take a look at the billing records from Aetna, then they should really only see approximately 5 hours of your time for counseling. Is that right?
I haven't seen my billing records, and I don't always bill based upon time because certainly some minimum amount of time would not have reached the standard to drop a bill.
Well, you billed under certain insurance diagnosis codes, did you not?
I would have billed CPT codes, which are the billing codes.
Right. And if we could pull up, if this...
Right.
All right, and it's in evidence. Insofar as what you actually billed for, would you agree with me it was complex regional pain syndrome?
I would have to see the bills. I don't know.
Sure. Would it refresh your recollection to see an email back from Aetna, the health insurance carrier, about the specific diagnosis code you used?
I would have to see the bill that was dropped related to the note, because that changes with the insurance carrier.
I understand. But we're talking about, and in evidence, are the billing records from Aetna Health. You understand that?
I don't see them.
That's okay. And so what I'm asking you is, insofar as what you billed under for Aetna Health, will you agree with me it was complex regional pain syndrome?
I don't know. I'd have to see the records.
All right. Would it refresh your recollection at all to see an actual message back from Aetna to, in this case, Beata Kowalski during this time, which sets forth exactly what code and what it meant?
If you could provide the CPT code, that would be helpful.
Sure. Can we bring up then what's in evidence is Trial Exhibit 2438-003? And I recognize it's kind of hard to see, but if we could focus in a little bit on that code down there. It's like in the center. G90, is that a 90.50?
I'm trying to improve the sound for you guys, doing what I can.
Unfortunately, this is still the ICD code. It's not the CPT code.
Okay, and what's the difference?
The CPT code are the billable types. So my billable CPTs are the way that you define what you did during that session, whereas the ICD code is what's presented here, and that's a specific diagnosis code. So there's two pieces to each bill, an ICD code and a CPT code. So you need the diagnosis plus what you did in combination.
So here, do they not specifically address Jennifer Katzenstein and a specific charge for professional services on a specific date, that being October 13th, 2015?
I see that, but I would have to see what I billed, not what the insurance company is passing along.
All right, so you think it's an insurance company's mistake that it's complex regional pain syndrome?
Sustained.
I can't know without seeing what I billed.
Did you ever check that?
I did not check that.
All right. And so are you telling the jury then if they go through it and they see a bunch of G90.50 on the Aetna billing that is not complex regional pain for you?
Objection, foundation argument.
Sustained.
I would have to know.
Maybe you don't need to answer that question.
I'm just trying to figure out how, looking at the billing, the jury would figure out how much you actually billed Aetna for your services, particularly for complex regional pain disorder.
Yeah. So to understand billing, what you have highlighted here is an amount that would have been associated with the CPT code. Okay. So in order for me to understand what I had billed and recall what I had billed from that time, I would need to see both numbers, that ICD code of the diagnosis and the CPT code of what services I billed.
That's what you would need, correct?
What I would need per what I entered into the electronic medical records.
Through the course of this, then, I see that you really had one reoccurring diagnosis here, and that was psychological factors affecting other medical conditions. Is that right?
Yes.
And that was the diagnosis you traveled under?
That was the diagnosis that I gave at the initial visit with the family.
And that stayed as your number one diagnosis throughout your records, did it not?
It maintained to me that there was a psychological component to an ongoing medical condition.
Well, right below that on your record, you say rule out somatic symptom disorder as per medical record. Is that right?
I don't have the note up, but yes, I believe that's correct.
And when you say rule out, that means you've ruled that out, correct?
Rule out means it's something that you're keeping on your radar. This is my first visit with the family. I spent 1 hour with them, and oftentimes it takes many visits to determine what the appropriate diagnosis is. So when you leave a rule out on your diagnostic list, it means that it's staying on your radar as something to think about.
All right. And so I never saw anywhere in your records where you ruled out that Maya was not having CRPS as a primary diagnosis. Is that true?
That would be beyond my scope as a psychologist.
Well, in your records, it continuously says CRPS is one of the diagnoses. Did you ever generate or receive any of the medical records that said we're ruling out CRPS?
Objection, Compound Foundation, the state senate.
Overruled. You can answer that question.
I did not, although it would be beyond the scope of my role as a psychologist to make that determination.
And you had to rely on others, right?
Correct.
Okay. And if they come in and say she has CRPS, then you're going to rely on that, right?
I rely on the medical team with me.
And so when you're talking about ruling it out, now once you have the diagnosis here and it remains CRPS, now you're in a position to rule out somatic symptoms to the extent you haven't already. True?
I'm sorry, I don't understand.
You don't understand?
I don't understand what you're asking.
Well, if you're trying to rule out something based on the medical condition, because you don't know it, right? Or you're not sure of it.
Correct.
And then you become sure of it or you know it, you can rule it out, correct?
I'm not sure at this point in time if I was sure or not sure of it.
Of the diagnosis of CRPS or ruling it out?
Either one. It wasn't within my domain to do that.
In any event, psychological factors affecting other medical conditions, that is a distinct and different diagnosis than factitious disorder or conversion disorder, at least under DSM, right?
In the DSM-5.
And do you accept DSM-5 as authoritative source for you in your profession?
At the time that it was current, yes.
All right. So now, this involves factors with strike that. So now, the other things you found were that there was no, from the time, the history you took and the time you spent with Maya and her parents, you did not find the parents having disruptive behavior or oppositionality or harm towards others, did you?
During my first visit with the family, they were cooperative and engaging.
And they continued to be cooperative and engaging, did they not?
I only spoke with Dad after that time, and he continued to be cooperative.
Well, Mom was also invited to, or should have been invited to go to the cognitive behavioral therapy.
Objection approach.
Okay, I neglected to share with you my my take breakdown of what the judge ruled on the DV stuff. We're going to do that towards the end. The DV motions were filed by Mr. Aldenbrandt, almost a week ago, I think. I think it was a week ago. And those are situations where he's asking the court that because the plaintiff has not produced any evidence to support an allegation, that the judge rule that the jury would not, the judge would direct the verdict to a not guilty sort of version. I mean, we're not talking about guilt and innocence here, but the judge would direct the verdict to mean that there's no liability on the part of the defendant because there's no evidence to support that allegation. So every time the judge ruled on those DVs and he said, I'm going to grant that. That means you're right, defense. There was no evidence to support that. And so that little allegation is now gone. The jury won't be considering that. And every time he says, I'm going to deny that, that means no, actually there was evidence. We did hear something that went towards that allegation. And so the jury will have to consider that. And for the most part, everything was denied except for small pieces that we had indications already that was going to be granted. All right. So I guess we covered it.
All right. And
the objection is sustained.
So you did receive some notice that Kathy Beatty was potentially a problem in supervising, if you will, Maya, did you not?
It has been discussed.
Say again?
It has been discussed, yes.
You did know?
Not at the time, but after.
Well, did you know by, say, mid-November?
During the hospitalization, I wasn't aware of any concern.
Okay. Would it refresh your recollection to see a writing directly towards that?
Yes, please.
May I approach you?
Yeah, sure, to Mr. Shapiro first.
Again, I just ask to approach it.
Okay.
You can review it, but don't answer anything right now.
Okay, so while they discuss this, sorry, it's really loud there in the background. Hopefully they'll turn the sound down. There we go. Okay. While they discuss this, I want to bring up, because we're at 1, 2, 3, 4, this was a significant number in the guesses amongst all those who were guessing how many total objections we'd have in this trial. Let's see. 1, 2, 3, 4. These are all the people who got this, who put this as their guess. So we got a handful of them, 4 or 5, maybe a couple more. But that's where we are.
That's all yours. Mike it. All right. Have you had the opportunity to refresh your recollection, ma'am?
I have.
And would you agree that as of November...
At this point, turn it over.
Oh, sorry.
Thank you.
Thank you. And at this point, would you agree that you were advised there were some problems with Kathy Beatty being involved?
Per this letter.
Object again to, objection foundation.
Overruled. You get an answer.
Per this letter, it indicates that there were concerns about Kathy and the supervised phone calls.
You did or did not?
I'm sorry?
You did or did not?
I just read that in the letter.
Okay, so you did know?
I thank you for refreshing my memory. I apparently knew on the date that I would have received that letter.
Okay, and that's all I was asking. And so now, following this, do you have any memory of actually checking to see how well things were working out between Kathy Beatty and Maya Kowalski?
There were team meetings and conversations, and I hope that I would have brought this up, but I don't have recollection of it specifically.
And did you ever do any background to check out whether Kathy Beatty was an appropriate person to be around this child?
Objection on approach.
Okay. While they approach one more time and they play the noise, I'm mixing feeds to get the best audio. I can show you there's another feed where she does not look quite as red, but we've got multiple feeds. This feed is my favorite. It does have a little more saturation in it, so yes, the people's faces look a little bit red, but for me, it's a little bit better quality, and it works better for what we're doing. So very few of the witnesses actually look red. It's just the way the colors come through. That's it. But good observation, though. All right. This was a huge win for the plaintiff. To find out that the hospital or someone on the hospital staff knew there were problems with Kathy Beatty in November, and that they did nothing about it. This has liability written all over it. So this is a huge win. This is why we saw such a ardent objection from the defense team early on, where Mr. Shapiro just would not sit down. They're still fighting it. They're fighting everything they can here. This is very damaging.
You can answer the question.
Can you ask the question again?
Sure. Do you recall ever looking into whether Kathy Beatty was the appropriate person to be supervising Maya Kowalski directly?
Not at that time. I did not provide the staffing to social work at that time.
All right. And would you also agree with me that Sally Smith, around this time, was part of the treatment team that was treating Maya Kowalski?
Objection, foundation correct.
Overruled.
Sally Smith was an external provider contracted by DCF.
That's not really my question.
She was not treating the patient in our organization, to my knowledge.
She was?
I didn't catch it. She was or was not part of the treatment team?
To my knowledge, she was not treating the patient in our organization. She was part of DCF.
Let's refresh your recollection really quickly.
So does that mean she was or was not part of the treatment team at Johns Hopkins?
DCF is a separate entity, and she was contracted separately.
All right. Would it refresh your recollection to see an email regarding this from Friday, December 9th, 2016 to you?
Yes, please.
Can I approach you on?
You may but show Mr. Shapiro first.
Sorry, I won't. This is what we walked through. We heard this already, and now we're watching Mr. Anderson very artfully navigate this course, and so far the judge has allowed it.
Does that... I'm sorry. Go ahead and read.
There was that chagrin.
You can turn it over once you're finished reading.
Thank you.
Does that refresh your recollection as to whether you or others thought that Sally Smith was part of the treatment team from Maya Kowalski?
Objection, speculation, foundation.
Well, also stated as it relates to or others, what her knowledge is. What
to her knowledge.
Or you said or others, so I'm sustaining it because you said or others.
Oh, I'm sorry. That she thought, or strike it. Did you then, having your memory refreshed, remember that Sally Smith was indeed part of the treatment team?
I do not recall this email. It was quite a bit of time ago, but in this statement, she was gathering the treatment team. I don't know that that makes her a treating member of the team.
So she was just gathering them together.
Have a conversation about what's been happening and gathering information.
All right. And so as of, let's see, it would have been, you started really treating on October, 8th, 9th, 10th, 11th in there?
The consult received on the 10th. The first time I was able to meet with the family was on the 13th.
All right. And so as of the 13th, your diagnosis was the same thing we talked about, the psychological factors affecting other medical conditions. Is that right?
Correct.
And that diagnosis in and of itself does not present a danger to the child, does it?
That
objection again. I need to approach on this.
Look at Mr. Anderson standing there and just like... Mr. Shapiro is trying to save any ground he can at this point. This is dangerous territory. The hospital liability is written all over this whole conversation, and man, the judge really did throw Mr. Anderson a little lifeline there, where he's like, "I'm going to object to where you said." Or others on your question. He basically said, please restate your question, but take this little piece out, telling him what he'd done wrong. And Mr. Anderson sort of bumbled it for a second, and the judge is like, no, that's the question was good. Just take or others out. And he was able to re-ask it and get it through. This is fascinating. The level of chess that's being played here is world class. It's really great. It's too bad it's all happening in a very tragic situation, but watching these legal minds work and navigating the courtroom is fantastic. Not as many people in the courtroom as I'd expect today. Maya and Kyle were here this morning, and I think they left prior to some of the testimony that we heard this morning. I think we saw them leave, actually. Honey, yeah, this is a great point. There are so many doctors that seem to be able to share a lot of information and recall things very exactly for the defense, but then on cross-examination, they seem cagey, and jurors can smell that.
Would you agree with me that at this point, the time you've reached this diagnosis, psychological factors affecting other medical conditions, that diagnosis, the diagnosis that you reached, did not involve any danger to Maya Kowalski?
Same objection, Your Honor, and same record.
Overruled. You can answer that question.
So in that case of that diagnosis, that is specific to the patient. And at that point in time, what I was seeing was stress and anxiety that were exacerbating the symptoms of pain.
And at that point, based on the record that you mentioned, with Maya not being in any, I got to figure out if I can ask this question.
This minefield is so crowded with dangerous areas where you cannot go. It's every single question we're going up to the judge, just running it by him really quickly. Hey, this is where I'm going next. This is what I'm going to say. You almost have to present it word for word. The judge is not like making a ruling far in advance and saying, I'm going to let you go here and here and here. Very much he's in the moment. It's like, let's see where the testimony gets us, where the line of questioning gets us, and then in the moment I'll rule on it. And you'll see this from many different judges. Very few like to really set up, rules that will not come into play until, a week down the road. Oh man, I'm giddy. This is crazy to watch. The hospital and the defense has taken some big hits today, some big hits that tie them directly. I'm talking about a parent agency. That's testimony today has come directly to that and linked their liability in this. Some nice headphones the court clerk's wearing. I wonder if it's a bring your own, and she brings the ones that are most comfortable. I would. I mean, if I had, as someone who wears headphones all day, every day, I find the ones that fit me nicely, that don't feel like a vice grip on my head at the end of the day. So. Pickles the cat says, someone can answer my question, please. What Pickles, by the way, is what our cat that has adopted us is named. And yes, it's still here. It's fine. I didn't see your question. If you ask it again, I'll try to answer it if I can. Anais Pauline, I definitely think he will. And I don't know what it will look like at that point. I don't know how they're going to move forward. I don't know what that will do to the jury questions at that point, which typically have been assigned to both sides.
And finally, you testified previously about potential rewards for Maya, I guess, cooperating, trying harder?
For working with the behavior chart where we would set clear goals.
All right. Well, in point of fact, she didn't receive a single one of those, did she?
I honestly do not remember.
Never checked to see whether she actually got a henna design on her hand or a coloring book, Shopkins, makeup, any of those?
I believe she did receive some things. There were a number of coloring materials, Shopkins, and at the time, again, before COVID, we had people coming into the hospital to do haircuts and be able to do those types of things. So I can't say with certainty that she did or did not receive them, except for the gelato. I do remember the gelato.
You never saw any of those things except for the gelato.
I saw the gelato.
Time for juror questions.
Dr. Katzenstein, I think you mentioned earlier from your perspective, Dr. Sally Smith was conducting her own investigation separate and apart from what you were doing at All Children's. Is that fair?
That is correct.
Your medical evaluation, let me clarify, your neuropsychological evaluation was independent and your own. True?
Yes, that is true.
Okay. That's all I have at this time, Your Honor.
Anything based on this couple of questions?
From the plaintiff, no, Your Honor.
Members of the jury, do any of you have questions?
Commence tearing pages out of your notebooks.
They're already packed.
You know what to do to get a break.
Okay, the doctor's being asked to leave.
Do not rise. Do not discuss the case. Do not do any investigation. Receive no information.
I'll tell you what I hear
We'll
on
see you
this.
in a little bit.
Okay, did you see the look on Shapiro's face when he's like, and from the jurors? He's like, here we go. Read question. This is the judge speaking. Read question number 1. What was the date of the letter regarding Kathy Beatty? Who was it from and to? Shapiro says, this is the problem that we were trying to avoid, but now we're going to get into it. I don't know if they can ask that. Mr. Carell says, I think that opens the... We object to the entire question. The judge says the date is not objectionable. The who it was to is not objectionable, but who it is from. Carell says, hearsay. Judge, hearsay. The judge says, I will not ask who it was from. And judge says, maybe I should ask it, was it directed to you? Carell says, the issue is that the letter itself doesn't say when the phone call. She's whispering now. Something about Kathy Beatty on the call, November 15. It's just rife with so many problems, she says. We would object to the entire question. The judge says the date that this witness received a letter indicating that there might be problems with Kathy Beatty is not objectionable. The court will receive that over the defense's objections. And that it was directed to Dr. Kastenstein is also be allowed. I will not allow the... She says, with the judge, the fact that it was written by an attorney, I don't... Yeah, okay. She's lost for words. The judge said, well, that's number 1. Read number 2. Why was Maya's statement about being afraid of the scary movie she saw in Mexico City significant? No objection. No objections. Read number 3. Why did you not make an appointment to see Maya instead of just showing up? That's a good. No objections from either side. Read number 4. Would you expect a medical doctor to own a DSM? What is the current DSM? When was it released? Wouldn't all judge is trying to make out what it says here. Wouldn't allodynia make henna application painful? Why did Nemours require an IQ test to transfer? Judge says, I think that word is allodynia. Shapiro says, I would object to number 1. I don't think she would know if it could harm her and what her expectation is of generic other doctors, whether they should be owning DSMs. Shapiro says, we'll withdraw our prior objection We object. Let's see. Whitney says we object to number 4. The reason is pure speculation. The judge says that's 6. There were 2 that were crossed off. Everybody's talking at once here. It's really hard to hear. Shapiro says, we think that the question is why there's an IQ test. He just trails off. Judge says, what's she going to say? Shapiro says she was asked to do it so they could give a foundational basis of what Maya's care was. Mr. Anderson says, I object to that. I don't think it's necessary. Judge says, I'm going to overrule that objection and allow that question. They're really talking over each other. This is really difficult right now, guys. Sorry. So on this one, there was no objection for any of the 4 questions that are remaining, regardless of what number was annexed next to it. Ms. Shapiro says, I think Mr. Whitley objected to a version of the DSM. I don't see Mr. Whitney on the screen. Judge says, I'm overruling the IQ objection. I'm going to ask that. Red number 5. Do you know, with your background, does CRPS have a component of stress/anxiety? Shapiro says, can you read that again, Your Honor? The judge says, I'm reading the next one to see if it sheds light on what that one is actually asking for. Krill says, I think it's asking if stress causes CPS. The judge says, do you know with your background of CRPS have a component of stress/anxiety? The next question is, how many children with CRPS have you treated or have been involved with your treatment at the time you were involved with Maya's treatment? Judge says, I think there's a word or two missing in that first question. Lisa Anton, welcome. Good to have you here. Krill says, are they saying, does it cause stress? Or is it caused by stress? Krill says, I don't think you can change the question, Judge. I don't think she's going to understand it. Mr. Anderson's reading now. Have a component of stress anxiety. The judge says, are you objecting to the first one? Krill says, I think it's confusing, but we don't object to it, says Shapiro. Shapiro says, I think it should be asked in red, and if she doesn't understand it, Krill says, the question is, Judge, it's unclear. Is it CRPS have a component, or does it stress cause CRPS? The judge says, I think if we change the word of to have, it really makes it clear. Do you know with your background, does the CPRS have a component of stress/anxiety? So we'll change the word. I'll ask the question. The other question was okay? Everyone says yes. So that's 5. So number 6. You are asked by counsel if the Kowalskis asked to leave the hospital prior to meeting with you. Would you know that if you had not met with them? The judge says, I think that's the question the judge sustained. Who was in charge of giving Maya the reward she earned, and when did that go into effect? Shapiro says, no objection, something about the first. Whitney says, with respect to the first one, she was asked on direct many times about whether the Kowalskis ever expressed intent to leave the hospital until this juror's exploring her basis for knowledge. Everyone's talking. Shapiro says, it was because Mr. Anderson asked about the 13th and 14th. Everyone is talking. I mean, it's like 50 horses, 50 riders. This is crazy. No objections on that. Shapiro says, no objections. I'm happy to explain it, but... The judge says, or Shapiro says, well, I guess the way I can put it, the way the question is worded, does she know if they were asking to leave the hospital prior Is that a yes or no question? Shapiro says, I apologize. Would you read it one more time? Judge says, you were asked by counsel if the Kowalskis asked to leave the hospital prior to meeting with you. Would you know that if you had not met with them? So I think if you had a period after the word hospital, says the judge, that would make so much more sense. Shapiro says, I think from a temporal standpoint, with her meeting with the Kowalskis on the 10th, maybe they're asking, what does she know prior to that attempt? The judge says, well, if I ask it, you can always follow up. Is there any objection? Okay, says the judge. Red number 7. You at one point in your written report mentioned that Maya, quote, was in an altered state of mind, end quote. Is that correct? I also believe you said that was when Beata was in the room. Is that correct? And did you say that Beata was answering your questions to or about Maya, and Maya was, well, in a different state of mind? The term you used, altered state of mind, sounds a bit Twilight Zone-ish. Could it be that Maya knew her mother could best answer in a more knowledgeable and coherent way than Maya could as a young child? So Maya was just occupying herself in, quote, kid things, unquote, while the adults talked, and not, quote, in an altered state of mind. Here it is, says the judge, hands on the paper. No objections. Mr. Hunter says, judge says, I've never seen The Twilight Zone, so I'm not going to date myself with that TV show. You want me to cue the theme music, Judge? Red number 8. I recall you stated that you worked for All Children's Hospital. Is that correct, in 2016? If yes, then go to the next question. There were a number of meetings that seemed to be missed because Maya was elsewhere. Is this therapy being important? Is there a reason why other staff had Maya out when she was to see you? Or were these meetings on a patient schedule or calendar? So staff at All Children's Hospital would know to have Maya available. Stephen, this is what I'm doing. I'm reading the reflections. Just 8 pages, that's all. Okay, they're going to bring the jury. Okay. Whew. That one was painful. I've never had them all talking at the same time like that before. That was pretty rough. Wow. Marmite, the second channel is Top Mark Media. Top Mark, all one word, like TOPMARK Media, and I'm just showing that Colorado case on it. We got permission from the judge for that one to restream the court WebEx, and so I think we're the only channel that has it. So we're just showing that for those people who are watching that trial and can't watch it live because it's not being televised live. I didn't count how many objections were in there. I can't count objections while I'm reading like that. So if you guys tell me how many
sit down.
you need to add.
Okay, please be seated. Okay, members of the jury, want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation, and you did not receive any information. Is that correct? Correct. And has anyone approached you about this case? Have you seen any media accounts? No. Okay, members of the jury, I'm going to be able to ask almost all of the questions. Dr. Kastenstein, I said that properly.
That was perfect, thank you.
The jury has a few questions.
I see.
What was the date of the letter regarding Kathy Beatty?
Oh, thank you for your questions. I have them up here. Am I allowed to refer?
You can look, just tell us the date.
Okay, November 18th, 2016.
And was that letter directed to you?
It is addressed to me, yes.
That's all I'm going to be able to ask as to that Next question. Why was Maya's statement about being afraid of the scary movie she saw in Mexico significant?
Thank you. That's a really good question. When we were doing that guided journaling, I asked her about her biggest fear. And she's in the hospital right now, separated from her parents, and in her perception, quite a bit of pain, and receiving PT and cognitive behavioral therapy with me. And when asked what her biggest fear was to write about, she chose the movie The Ring.
Next question. Why did you not make... Okay, let me reread it again. Why did you not make an appointment to see Maya instead of just showing up?
Oh, this is a very good question, because it's how our lives function when clinically you have a full outpatient schedule and you need to be in the hospital. So think about when you go to a doctor's appointment and your doctor is back to back to back all day long. I'm trying to find time, honestly, to squeeze over, to run over to the hospital to be able to do the consultations that need to be done for my census, and then get back to my desk either for my next patient or meeting or to follow up on clinical work. So when you're balancing the two of those, sometimes they're unpredictable. And if you have a no-show, then you have time to run over, but that can be challenging. Sometimes you can call over and say, is Maya available, or are parents there? But then also sometimes when you come over there, you're more likely to even find them because they might run to get a cup of coffee or something might be happening. So you're balancing trying to track the family down versus everything else that you have ongoing outpatient.
Next question. Would you expect a medical doctor to own a DSM?
Oh, that's another great question. A psychiatrist is a medical doctor, and sometimes that can be confusing because I'm a psychologist, which means I have a PhD, and a psychiatrist would have an MD. So yes, I would expect an MD to have a DSM. However, not all physicians, not all MDs and specialties would I expect to have that, and many I would be very surprised if they did.
What is the current DSM?
The current DSM is the DSM-5 text revision. So the one that was current at the time of this admission was the DSM-5, and since that time there's been an updated edition of the text revision. It says DSM-5 TR after it.
When was it released, the DSM-5?
Gosh, that's a very good question. Probably 2.5 years ago, 2 years ago. I don't know exactly, but it came out during COVID, which is really just a time. No.
The question is, wouldn't allodynia make an henna application painful?
I can't speak to that. I personally have not received henna, so I can't tell you how that feels or it doesn't feel, or what someone's perception of pain might be in that situation.
Why did Nemours require an IQ test to transfer?
That's a great question as well. Our transfers, when we go to another organization to ask for a patient to be accepted, have different requirements, and so I can't speak to why Nemours would require that, but I was asked to do it because I make the assumption that that's part of the criteria they're asking for in considering the transfer.
Do you know, with your background, does CRPS have a component of stress/anxiety?
For CRPS and other pain conditions, there is often stress and anxiety, and that is why cognitive behavioral therapy and working with a therapist or a psychologist is a key component of the treatment plan.
How many children with CRPS have you treated or been involved with their treatment at the time you were involved with Maya's treatment?
At the time of Maya's treatment, I had no other patients with a diagnosis of CRPS.
You were asked by counsel if the Kowalskis asked to leave the hospital prior to meeting with you. Would you know that if you had not met with them?
I may or may not know that in a typical situation. However, in this case, I was not aware of that.
Who was in charge of giving Maya the reward she earned, and when did that go into effect? What date?
So unfortunately, per my recollection, we weren't putting the behavior chart together with the clear goals as quickly as we would have liked. And so typically in that situation, our child life team members, along with myself and physical therapy, would get together to discuss that. But we weren't able, to my recollection, to put that together and put it in place.
So they dangled a carrot and never gave it to her. That's just low.
At one point in your written report, you mentioned that Maya, quote, was in an altered state of mind, end quote. Is that correct?
Oh, I would have to see that note. Altered mental status, I believe, is the words I would have used.
I also believe you said that was when Beata was in the room. Is that correct?
In my first time meeting with the family, that is when she did not participate in the session, and I did note in my mental status that she had an altered mental status, and Mom and Dad were both present.
Okay. Did you say that Beata was answering your questions to or about Maya, and Maya was, well, in a different state of mind? The term you used, quote, altered state of mind, end quote, sounds a bit Twilight Zone-ish. Could it be that Maya knew her mother could best answer in a more knowledgeable and coherent way than Maya could as a young child, so Maya was just occupying herself in, quote, kid things, end quotes, while the adults talked and was not in, quote, in an altered state of mind, end quote?
It's a great question. In many cases, when I am working with children in this age, they let their parents answer because their parents have typically answered or because their parents have the words and the information. However, in this case, I noted it because she had been conversing with me previously and was not engaging. And the altered mental status means that she didn't seem to be present as much with us. And so even if I have a patient who is coloring or playing a lot of times with toys that we have in the room, then a lot of times the kids are still listening and present with us.
I recall you stated that you worked for All Children's Hospital. Is that correct, in 2016?
In 2016, I was employed, yes, by All Children's Hospital.
There were a number of meetings that seemed to be missed because Maya was elsewhere. This therapy being important, was there any reason why other staff had Maya out when she was to see you?
Thank you. It's difficult to manage everyone. Again, our physical therapists are coming in when they have time and they're managing a significant caseload. I'm coming in as I have time. So it's a great opportunity, of course, to make a schedule that everyone can abide to, but unfortunately it doesn't always work out that clearly.
Okay. Were these meetings on a patient schedule or calendar?
No, there was no patient schedule or calendar. To my knowledge or recollection.
And I apologize, I didn't finish the rest of the question. No, I thought that was the end of the question. Let me just re-ask it. Were these meetings on a patient schedule or calendar so staff at All Children's Hospital would know to have Maya available?
That's a great question. That's something that we really worked towards. Unfortunately, at that time, we didn't have a really clear system in place to be able to do that, and we continue to work on that even to this day.
Any follow-up?
These are great ideas, and we still haven't done them.
A very good question about trying to get a regular therapy session. Was that one of the reasons why you were advocating or recommending to the Kowalskis transfer to Nemours?
Yes, it was difficult for us. We did not have a comprehensive pain treatment program at that time that would have scheduled appointments and have OT and PT and cognitive behavioral therapy coordinated, and Nemours was doing that, and they still do it really beautifully.
Thank you.
At that point, Nemours did not have an inpatient CRPS treatment program, did they?
My understanding at that time, they had an intensive outpatient program.
It was outpatient. They did have an inpatient psychiatric program, did they not?
I do not know. Currently, to my knowledge, Nemours does not have inpatient psychiatric treatment.
All right. When you said an altered state of mind, the fact that a child doesn't respond to you, that doesn't warrant a diagnosis of altered state of mind in and of itself, does it?
There is no diagnosis of altered state of mind.
Because you don't have any answers from the child, correct? The child just doesn't answer.
I'm sorry, can you ask?
Wasn't your concern that the child was not responding to you as well?
My concern at that first appointment was that Maya was not engaging as she had previously.
Right. She was not engaging with you, for instance, because she was happy to see her folks. That could be a reason, true?
That could be one reason.
Right. She could be not responding to you because she was tired.
That could be a reason.
She could not be responding to you because maybe she didn't trust you as an agent of Johns Hopkins.
All of these are options, reasons why. However, in that situation, she had previously spoken with me.
It could be that at the time she was on so many different meds, it was hard to tell exactly what her base level was. True?
I can't speak to that. I haven't seen her medications, and I'm not a physician.
Well, hang on. You didn't look to see what medications the child was on at the time you were examining her?
It would be beyond the scope as a psychologist to be managing medications.
I'm not asking about managing medications. I'm asking you whether you were aware, for instance, that Maya at that time was on tramadol.
I would have to see the notes.
Valium.
I would have to see the notes.
Ativan.
The objection, lack of foundation.
Sustained.
Is it true that any one of those have significant psychological potential impairments?
I can't speak to that. I'm not a physician. I do not prescribe medication.
And you don't think it's important to know whether the child has got multiple mind-altering substances in their system at the time you're interviewing him?
Objection, foundation.
Overruled. You can answer that one.
I was interviewing her. She had been in the hospital for a period of time, and she had been interactive with me.
But you had no baseline because you never saw her without all of those drugs in her system. True?
I can't speak to the days prior in which I did engage with her.
Any further questions?
Just very briefly. If you could bring up Joint Exhibit 1001-3826. And for the sake of expedience, Dr. Katzis, I'll represent to you this is your note of October 13th when it comes up. Okay. 10013826.
Amanda, that's hilarious.
Sorry about that. I had to push the button. That was all me.
So I need 10013826, please. And then under the histories, do you see this? I just wanted to see if you could clarify the jury. There was discussion of what terms you used. Can you describe what you meant by altered mental status in this note, Doc?
I wrote altered mental status. Maya's pain and current emotional status impacts her ability to report. Her parents provided history described below.
In previous or subsequent interactions with Maya, were you able to determine that she was very interactive and conversant regarding her medical care?
Yes.
So is what you're describing here a change from when her mom's in the room versus when her mom is not in the room?
Objection. Leading.
Are you just, let me just ask you, based on your observations of Maya, did you notice a difference in Maya's interactive level depending on who's in the room?
On this date, I noted a difference. I did not make assumptions beyond pain and current emotional status.
I appreciate your time. Thank you.
See if there's any more follow-up from the jury. No.
We've got some more questions. How many do we have coming? Okay, we'll just stay here.
He says that, but he's standing right now on the Zoom feed. If he stays here, we don't get to hear the audio. If the jury stays, it looks like they will. So I won't be able to tell you what these questions are. We'll just have to hear the ones that get approved. For those that were asking about the second channel, all I'm showing on that channel right now is the Adams County, Colorado trial of police officer Woodyard, and that is the People v. Woodyard trial with Elijah McLean. There were 5 police officers accused in his death, and the third officer is being tried right now. One has been acquitted, one has been convicted, and this is the third officer. But that's over there. This is on Top Mark Media. That's the only thing over there right now. So if you want to watch that, unfortunately, it's not the best court feed. Sometimes they cut out and don't give us portions of the day, and I can't do anything about that.
Doctor, just to clarify, the Shopkins and gelato treat you testified Maya received were not part of the reward chart you created with her because it actually never got put into place.
That was my understanding, that it didn't get put into place, but also our child life team is pretty fantastic and they knew things that she would like, so they may have just been things that they got her at that time. But to my knowledge, that behavior chart did not get put into place.
Do you know where the Shopkins and the gelato came from?
I do not. We have a number of very generous people who donate to the hospital, and there are rooms and rooms of toys. And so I'm assuming that it came from one of those places.
Thank you very much.
I have one question.
Sure.
And this is on Joint Exhibit 1001-3759. 3759. And I'll represent to you, Doctor. This is your note from December 20th. And these were the potential rewards that you were setting up for Maya. And was this part of your plan of incentive behavior?
Yes.
And I just think, as the jury had the question, this would have been about 3 weeks or so before Maya was discharged from our children's.
Will you remind me the date?
Okay. Yeah.
I trust you.
This was towards the end of her hospitalization.
Okay. Yes, this was in the second half to later third.
That's all.
In truth, you had no idea where the Shopkins came from.
Is that the question?
That was my question, and she said, I think no. She did not.
I said correct. I didn't know exactly where they came from.
May I ask one more question? Last one. Was the list of rewards, those are what Maya had conveyed to you that she had wanted?
Yes, they were directly from Maya.
Okay, thank you.
May this witness be excused at this time?
Yes, sir.
Yes, but still under.
You need to remain under subpoena, which means you can leave for today, but you might get called back.
Okay, so nothing, no media or anything.
I'm sorry?
No watching anything, no
watching.
Okay, thank you.
No media, no interviews. Still under subpoena.
Defense, your next witness, please.
This should be a few minutes.
You're suggesting this is a good time for a break?
Yes, sir.
Members of the jury, let's try to keep this to no more than 10 minutes. Do not discuss the case amongst yourselves. Do not do the investigation and receive information.
All rise. Jurors act to take.
Thanks, Rob. I just got it. Okay, so as the jurors leave here, interesting little back and forth there with the questions. The jurors' questions.
Presence. Any issue before we go
they're
break?
on it. They're on it.
Reporter, do you have the question that Mr. Anderson asked marked? Or no? It was anyway. We can find the transcript and deal with it later on. Nothing from the defense.
Judge, I'm going to clear.
Judge is halfway out the door.
So we're down to 9 minutes for our break.
Okay.
Scores are recess.
It's interesting that she would ask the judge, so no media, meaning I'm not sure if she says no talking to the media or no watching media, but the judge made it clear that's not allowed. But it's great. Let's see. I just missed a call from Jules. Hang on one second. Come on. Jules, if you can call back one more time, just 1 second. It just picked up and then dropped again. I think it was because I have the Zoom running. Okay, we're going to try to connect with Jules here on this break and get her take, as she's been attending this trial in court every day, and she's there today as well. So she's probably out during the break right now. I'm going to see if she can call in one more time because my phone just disconnected really quickly. All right. Any other questions on Be Kind Tiger? I haven't linked the 2 pages. The reason why is this channel, we do a Pickles, not politics, is sort of a motto here, where we really stay away from political issues, both in topic of what we watch as well as in our discussions. The other channel is going to be a little different. Not that we're going to talk about politics or we'll have a political slant to it, but we're going to be watching some trials that are more political just in nature, and we'll be following some things that are a little more political. So I wanted to separate the two for those of you that like to go somewhere where there isn't really a political discussion also taking place. That's why I separated the two out. Okay, the non-answer about why therapy never happened, coupled with the no reward for incentives were both really, really sad. CC Mango, yes, and the fact that she's like, yeah, in the perfect world, we'd have a plan for all this. Jules is calling in again. 1 second. Hey, Jules, can you hear me?
Yeah, I can hear you. Can you hear me?
Yeah, I've got you turned up there. Thank you very much. Sorry I missed your call a second ago.
No, I just want to tell you, I ran outside.
I could tell that. Thank you so much.
Yeah. What do you call it? Oh, my God. They don't like her. They just don't like her.
Yeah. What were you seeing from the jury that we couldn't see during that last witness?
They don't like her. They just don't like her. 7, definitely by his facial expressions, like raising his eyebrows. He was making faces. I mean, I don't have my notes with me. I left them upstairs in the courtroom. Mm-hmm. But when it came to jury questions, all but two had questions.
Wow.
Yeah.
This is not looking good for the defense. This must be, I mean, put yourself in the defense's shoes. They are in the eyes looking over at the jury every time they look over, right? And this is what they see. They see the faces, they see the incredulous looks, they see the shaking of the head, they see the pursed lips.
Shapiro is not having a good day. And I now know his tell. Now I know when something doesn't go his way, I have his tell. He let me see if I'm looking at him, so it would be the left side. He kind of like clenches his lips and the left side of his mouth goes like up. So I've been watching. Watching. Yeah, like, oh shit. I'm sorry. I didn't mean to say that.
7 dirty words. No, you're good. So that's going to be his tell. So if we ever play poker with him, we'll know what to watch for. But we'll look at that as well. So do you think it seemed like earlier today, Mr. Shapiro just about opened the door to the whole issue of SA?
Oh my God, you have no idea. What? We were literally on the edge of our seats, and I'm telling you, honest to God, I thought the judge was going to let it in. I did. And then the judge was like so close, and we and the spectators, we were like, not going to lie to you, we could have gotten into trouble. We were buzzing. Okay? We really thought he was going to let it in, and then he went and took that damn break. to think about it.
He reset.
And when it came back, yeah.
I think it was frustrating for those that think that Maya should get some justice in that issue in this case. To see it be not allowed is frustrating for many people. But I think the judge was looking at this saying, the plaintiffs has sought out a jury trial. And if I bring this in, any result is going to be overturned, appealed. It'll just start over. So maybe it was the wiser course of action, even though it wasn't popular. But credit to him for being able to stop and reset and look at the picture, big picture.
I suppose so, but I'm going to tell you, I'm glad that Maya and Kyle were not in the courtroom before court actually started, because I'm sure you saw what went on there.
Yeah, there was.
The defense is doubling down with she never had CRPS. It was Munchausen by proxy. It was fictitious disorder. Basically, what they're saying is Maya lied.
Yeah.
Okay, and they're doubling down
and she's still lying,
on that.
Right?
Yes.
They lied.
Correct.
We don't believe her then. We still don't believe her now.
That is the narrative. They are sticking with it. They are not letting up. And I'm glad the kids weren't there, but then they did show up. And when what was the one? Menendez. I might be saying that wrong. Mendez. I think it's Mendez. Maya left. Kyle and Maya. I don't know if you saw it on camera.
We saw them walk. They left together.
They left together. Correct. And they have not been back.
No, I was disappointed.
That's all I got for you.
I thought there was going to be a question where I thought they were going to ask about the testing, the nerve testing they did, where they stick a needle in you and it's extremely painful, and adults don't tolerate it well, and Maya just sat there with it as if nothing was going on. I thought they were going to ask about that because there are all these people saying she doesn't behave like somebody in pain should behave, and yet we have this hard evidence that when they're physically causing pain to her with this nerve testing, that she's just fine and doesn't behave as if she's in pain. That has to add up. I mean, you have to be able to put those together. You can't just have one side and not look at the other.
No, you can't. But I do have a question for you.
Mm-hmm.
With the jury questions, well, not even the jury questions. When Shapiro was doing his direct on this one here, did she not come off, because me and Alicia want to know if we're just crazy or not, did she not come off pro J Hatch and she wasn't going to let up on that?
Yeah. It seemed the presentation, how she was answering the questions, very much leaned like I'm talking to my side now, and then I'm talking to the other side, the enemy. It was.
Yeah.
Let me ask you one back then. She said good question several times to the jurors. Was there any eye roll or anything on the jury side? How did they receive that? Great question.
7-11. The eyebrows went up, and 7 keeps his face in his hands, and he's got how do I explain this? He's got his index finger on the right side of his cheek, and then the rest of his fingers are under his chin. Does that make sense?
You're saying he's flipping the bird?
No. His index.
Oh, sorry.
His
like
index.
this. Sorry. I was thinking middle for some reason.
No. His index finger rests on his right cheek, and then the rest of his hand is under his chin.
I'm trying to model it here. Yeah.
Yeah, and he does the side. He gives the side eye up to the ceiling.
Wow.
Yeah. So 7's my man.
Wow. That's telling. Great questions out of the jury today as well. I'm just excited.
So too.
They're coming back to court right now, so I'm going to let you get back in. Thank you very much, Jules. We'll see you.
Have a great day.
You
Bye.
too. Bye.
For our planning purposes, Wednesday will be another day of we have to hit the 12 o'clock mark. But I think that's as I sit here right now, that's the only other day this week that I have to hit a specific time. Anything else before I bring in the jury?
Don't believe so, Your Honor.
No, complaint, Mr. Your Honor. Let's bring in the jury. Yes, sir.
Thank you very much, Jules. We appreciate you being in the courtroom and being able to share what you see there with us, as we can't see everything that you see. So that is fantastic information, and it confirms in large part what we are able to see with the juror questions. All right, the jury's coming in. Let's see who we've got next. Did they say Dr.
All rise. Jurors at jury.
I'm trying to see who we have next. Are we doing the Malik Depot? The Brandon Alexander Depot? That's not yet. Dr. Elliot Crane? Is it Dr. Elliot Crane that's next?
Okay, please be seated. Members of the jury want to confirm while you're away you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct? And no one approached you about this case, is that correct? And you haven't seen any media coverage? Mr. Hunter, your next witness, please.
Defense calls Dr. Richard Elliott.
Defense is calling Dr. Richard Elliott.
Dr. Richard Elliott.
By calling, they literally walk out into the hall and call him. This is a pain management board, so maybe this is going to be the question. We can hear the question about how she tolerated that nerve test.
Raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but?
I do.
He's got a big bag with him. It's like a suitcase. He's got everything he needs.
Hey, police court. Tell us your name, please, sir.
Richard Andrew Elliott.
And what is your occupation?
I am an anesthesiologist.
Okay. And by whom are you employed, sir?
Johns Hopkins, all children's specialty physicians.
Okay. Would you tell us where you got your undergraduate and medical training, please, sir?
Certainly. I am from Ohio, and I did a rather unique program, a 6-year BSMD program, where I did my bachelor's degree and my MD in 6 years rather than the traditional 8, and that was through Kent State University in Ohio, as well as a medical school there called Northeast Ohio Medical University.
Okay. And you got your MD from there?
Yes.
And where did you go after that?
I moved to Baltimore for my postgraduate training. I did an internship at a MedStar hospital called Union Memorial Hospital in Baltimore, and then I did my general anesthesia training at the Johns Hopkins Hospital there with the School of Medicine. And then I subsequently spent extra time doing pediatric training for an additional year after that.
Okay. And when did you complete? So you did a residency and then a fellowship.
Yes.
And when did you complete your fellowship training?
I finished my fellowship in 2003.
And fellowship was in what field?
Pediatric anesthesiology.
And did you become board certified in any specialty?
Yes, I have 3 board certifications currently. I'm board certified in general anesthesia, pediatric anesthesia, as well as medical acupuncture.
Okay. And where have you, tell us where you went to work after you finished your fellowship.
So after fellowship, I actually was in private practice for almost 2 years. I was in practice around D.C. At a community hospital there that I worked in conjunction with D.C. Children's for about 2 years. And then I wasn't doing as many children as I would like at that point. And so I ended up going back to Hopkins in 2004, end of 2004, really like December of 2004, to join faculty there doing both anesthesia and pain.
Okay. And how long were you at Johns Hopkins in Maryland?
I was there until December of 2013. That's how long. So basically about almost 10 years, 9 years.
And where did you go in 2013?
In 2013, I moved down to St. Petersburg and joined the group at All Children's Hospital.
Okay. And what is your role Well, what role did you undertake at All Children's Hospital when you moved in?
I'm an employed physician there, but my roles included really recruitment to do help enhance their regional anesthesia and pain management program was my main reason for going there career-wise.
Okay. And what do you do at Johns Hopkins today?
So today, I'm currently the director of inpatient pain management, and I also so I split my time between the OR as well as inpatient acute pain management, and I also do outpatient chronic pain management.
Okay, and is that what you were doing in 2016?
Yes, except for we had not started. We were working on getting our outpatient clinic up and running at the time. It was not active at that time.
Okay. So in 2016, tell the jury what the scope of your practice was and what your professional activities consisted of.
I'm on the court Zoom.
Sure. So obviously my care for patients revolved around the perioperative period or peri-procedural period, putting kids to sleep and making them comfortable for surgery or other things, MRIs, other diagnostic studies, as well as managing pain on the inpatient side. We have a pain service that's a consulting service that we staff with both physicians and APPs, meaning advanced practice providers like nurse practitioners or physician assistants that we work to help manage pain in all its forms for hospitalized patients.
Okay. Now, tell the jury, if you would, what the scope of your practice is or was in 2016 in managing inpatient chronic pain consultations.
So back then, and as I say, we get a fair number of chronic pain patients in the hospital. Whether they've had surgery or they've had other things going on, we get involved with their care. In most of the time, we're consulted by the primary service, meaning the pediatricians, to help with that.
So that could be pediatricians or intensivists?
Surgeons, intensivists, anyone that would like our advice on managing pain for a variety of reasons, acute and chronic pain.
Okay. Now, you mentioned that you now have a outpatient chronic pain practice.
That is correct.
Tell the jury about what that is all about.
Yeah, so just like any physician, we have a clinic in the outpatient setting where we make appointments with patients, and they can be referred to us to help manage their pain in an outpatient setting. And a lot of that also involves, we have a multidisciplinary pain program. So all our patients that come to us are met not only by one of the pain doctors, of which we have 4, they're also met by our pain psychologist, and they're also met by our physical therapy colleagues. And we meet with the parents as well as the child and do a 2-hour visit for our first visits. As well as then we do follow-ups from that, as well as follow-up appointments from patients that we've seen in the hospital that need further care that we manage.
So, but to be clear, that outpatient pain clinic was not in operation in 2016?
That is correct.
When did y'all start that?
I believe it was, don't quote me on this, but I believe it was around 2018 or 2019 that we really got that fully established. Somewhere in that. It was definitely not at that time, but probably at least a year later or so, but we were working on the logistics of that.
So as of 2016, there was not an outpatient chronic pain clinic per se.
That is correct.
At Johns Hopkins All Children's. Is that right?
That is correct.
Okay. But you were consulting on chronic pain patients on an inpatient basis.
That is correct.
Okay. And as part of your experience and training up to that point, had you had any experience with chronic regional pain syndrome?
Yes, of course. Throughout from day one of my training, throughout my career, from the time I finished my training in 2003 till now, and which has been 20 years, it's hard to believe. I've managed patients with CRPS. It's not a common condition in children, but certainly had and I interacted with in Baltimore. We had Kennedy. We were associated with Kennedy Krieger Institute, and they had a chronic pain program there that we were associated with and involved in during my time there. So yes, I've seen that, and now we actually have our own CRPS program.
Okay. As of 2016, were you familiar with the treatment of pediatric chronic regional pain syndrome?
Yes, I was very familiar with that, and had obviously in Baltimore taken care of patients with that, but yes, well versed in that, yes.
And what does the treatment of pediatric chronic regional pain syndrome consist of, or what did it consist of as you were familiar with it in 2016?
Yeah, it really hasn't changed in that time period, but the basis for treating pediatric CRPS really revolves kind of around functional restoration, meaning physical therapy, occupational therapy, as well as what we call cognitive behavioral therapy, which is a form of psychological intervention to name it. So those are pretty much the standard treatment for pediatric CRPS to this day at the children's hospitals throughout the United States.
Okay. In your chronic pain practice, did you also have occasion to encounter pediatric patients who were suffering from functional neurologic disorder or conversion disorder?
Yes, for sure. It's not uncommon for patients with CRPS to also have either have a comorbid conversion disorder or be misdiagnosed with one or the other. But it's not uncommon to have functional neurologic disorder with CRPS.
And how does strike that. What, as of 2016, what was the treatment with which you were familiar of pediatric conversion disorder or pediatric functional neurologic disorder?
The treatment is very similar to that of CRPS. It consists of very much, returning patients to function. And it's important to highlight that, whether it's CRPS or functional neurologic syndrome, we believe patients and they have true pain and issues. So the treatment really is the same for both of them. It's really physical therapy, occupational therapy, and then cognitive behavioral therapy is the treatment for both of those conditions.
The treatment, strike that, conversion disorder, functional neurologic disorder, both of those are psychological factors, psychiatric conditions. Define what those are for the jury, if you will.
Yeah, the functional neurologic disorder or symptom disorder is defined in the DSM, which is really, considered a psychiatric diagnosis. However, when we see patients with that, we don't treat them any different, and we believe that they have pain, and we don't, say that it's in their head and this, and so it's treated the same, and we focus on that their pain is real, whether it's CRPS or functional neurologic disorder, and we move forward with those interventions and support those interventions, the cognitive behavioral therapy, the PT, OT, to really get them back to functioning and reintegrated into being a normal kid.
So can you give the jury some idea of what this physical therapy and occupational therapy that you're describing for CRPS and conversion disorder, what it consists of?
Yeah, sure. So it's important to understand that patients with whether it be CRPS or functional neurologic disorder, really the nature is that they want to avoid moving the extremity, avoid that pain, but the data in pediatrics shows that that's actually the wrong thing to do. That what happened in a lot of these, that the way the brain is firing is it perceives pain or other issues that aren't really there, and in order to kind of get that off switch for lack of a better word, that off switch on again, you must do progressive physical therapy. And what I mean by that is you start very, very slow, and then basically work with them and increase that to get that extremity or what they need. Most often with CRPS or functional neurology, we're dealing with extremities. They need to use it. They cannot avoid to use it, because you'll never get that way your body works. Those way your body works, that on switch won't be turned off and start functioning normally until you do physical therapy with that. And there are actually MRI studies validating that, looking at kids.
Section bolstering.
Sustained.
Can you talk about what
moves and request for instruction to strike?
The jury will disregard the comment about the studies.
Can't talk about what the literature shows.
Sure.
Just talk about what your experience and your training has been.
Okay. No problem. So we do see that really, with support of both the physical therapy, occupational therapy, and with the cognitive behavioral therapy to deal with the stressors that go along with these conditions of missing school, not being able to participate, brings these kids most often to remission.
And when you say the focus is on function, what do you mean?
Well, a lot of times, and we're very honest, that in pediatric CRPS or functional neurologic disorder, functional reintegration is very, very important, meaning trying to get the kids back to school, trying to get their social activities up, doing things. And so a lot of times in pediatric CRPS, functional restoration will often precede pain reduction, meaning that getting them back to lives that they in those things in their lives, whether it be school, social, other things, is very important in progressing them to having that reduction in pain.
Okay. Now, is there a role for medication, for pharmacology, specifically ketamine, in the treatment of pediatric CRPS or conversion disorder?
So the treatment for it is as I shared. However, we do believe that medications can be used to facilitate some of those things, meaning we do give medications to help facilitate physical therapy in terms of helping with pain reduction in order to participate in those endeavors in that. In particular, ketamine, we don't routinely use ketamine for those endeavors, especially on the outpatient setting. We do use ketamine for low-dose ketamine for the treatment of some pain conditions, mainly as an inpatient.
Okay. And when you say low-dose ketamine, what do you mean?
It's described at what we call sub-anesthetic doses, meaning doses that are way below anything that we would give for, say, surgery or sedation for other procedures or anesthesia.
Turning, perhaps prematurely, we need to go back here, but turning to this particular case, how did you first get involved in the case of Maya Kowalski?
So my first involvement was, I believe I was on vacation. I received a phone call from one of my colleagues about this, just had I ever really seen doses as such, meaning the doses, the high doses that Maya was receiving. And so my colleague reached out to me, most likely because I had the most experience with pain and was working on starting our chronic pain clinic, and was just wanting to understand and see my thoughts on these very large doses of ketamine that were reported to be given.
And were you given an understanding at that time? Who called you? Do you remember?
It was Dr. Dolan, my colleague.
Okay. And were you given an understanding at that point of what level of ketamine doses the patient was being treated with at the time that she was admitted to the emergency room on October the 7th, 2016?
That phone call really just was in regards to what I recall, the doses that she was receiving as an outpatient at Dr. Hanna's office.
And did you get an understanding of what doses were being used, what was being given?
Yeah, it shared with me the doses that were being
Objection, hearsay.
Sustained.
Offered to prove what he was told, Your Honor.
Sustained.
It's for the truth of the matter. That's called hearsay.
Did you acquire an understanding of what doses Dr.
Same
Hanna
objection.
was using to treat Maya Kowalski with ketamine?
Objection. Still hearsay.
Well, that question he can ask.
My colleague
Oh.
shared with me doses that were administered.
Objection. It's hearsay. Move to strike.
The answer stands. Your next question.
And did you, well, strike that. What was your reaction to the volume of ketamine this young lady was being given?
I was quite surprised and shocked at the amount of ketamine that was reported.
And why was that?
Because they were way higher than any doses that I had ever seen given to a child.
And now, at that time, were there certain guidelines in effect at Johns Hopkins Children's Hospital regarding the use of ketamine in pediatric patients?
Yes, we have guidelines, especially for pain management. We have a policy that we have for the use of ketamine for pain, which is, again, as I shared, sub-anesthetic doses or lower doses that we will use on inpatients to help with pain.
And the doses with which you became familiar that were being used by Dr. Hanna, how did those compare with the doses that were in the guidelines at Johns Hopkins Children's?
They were over 50 times higher than anything that we would recommend.
Okay. You mentioned something that we need to go into a little bit. You mentioned sub-anesthetic doses versus anesthetic doses. Can you make that distinction for the jury with respect to ketamine?
Sure. So ketamine is FDA approved as a general anesthetic, and we do use it to induce general anesthesia in pediatric patients. And so we use that as our benchmark. So when we say sub-anesthetic doses, meaning doses that are below that we will use to treat as an adjunct to treat patients with various pain conditions. So an example would be, I would put a child to sleep with a certain dose we base everything on weight in pediatrics. So I would use, for instance, ketamine 1 to 2 milligram per kilo to induce general anesthesia. To give them pain, to use it for pain, we would use anywhere from, say, 0.07 to 0.2 milligram per kilo. So much less is what is in our guidelines for that.
And by comparison, what doses did you learn were being given by Dr. Hanna?
Those were, if you when I did the math, it was up to, if you break it down by hour, it would be 25 milligrams per kilo per hour in some instances.
Now, you've told us that you got this phone call about Maya Kowalski's case while you were on vacation, off service. Did there come a point a day or so later when you became involved in her case on the job, so to speak?
Yeah, I believe when I came back from vacation, I was the doctor that came on service. We rotate; it's very normal. We rotate weeks on the pain service as the doc. So I came on the following week, following her admission. I believe it was the 10th, October 10th, that I came on service.
Okay. And at that time, were you the primary pain management anesthesiologist on her case?
Yes, that is correct.
Okay. And can you describe for us, if you need to look at your records, you certainly can do that, but can you describe for us what your evaluation and treatment of Maya Kowalski consisted of on that first day, October 10th, 2016?
Yes, certainly. It was very typical of my routine in that whatever patients we have on service from the week prior or the weekend, I usually take a look at their charts and review the records, and then at some point during the day, I will go and see them and see and examine them, and that's a typical. I believe in the afternoon that day, I was when I was able to go see her, and I met, I believe, Mr. Kowalski on that day, and really just took the time to have him share with me Maya's story and spend a fair amount of time listening to him, as well as sharing our thoughts that day as well.
All right. And at that point on October 10th, I believe that would have been either Sunday or Monday, what was the treatment plan in place for Maya Kowalski?
So the treatment plan had kind of been to give her several days of modified infusion of ketamine, and this is all in the ICU with ketamine, as well as another medicine called dexmedetomidine, and then begin to come down on those slowly in the ICU, watching for any issues, balancing, helping manage her pain with any risk of withdrawal from any of the medicines that she'd been receiving.
Okay, now, of what concern was the question of withdrawal at this point?
Well, in my mind, it was still unclear, all the medicines that we were still trying to gather information, unclear of all the medicines that Maya was receiving. At that point, I had not had a chance to reach out to Dr. Hannah, and so we were being extremely cautious in terms of balancing helping Maya with pain as well as making sure that she didn't withdraw from anything, and that was also for the reason for the addition of the dexmedetomidine. It's a medicine that we use for agitation, but it also works to kind of help with potential of any withdrawal that may be there.
Now, did you have a chance that day to speak with Dr. Hannah?
I don't know if I called him that day or it was. I believe it was on the next day, October 11th, that I spoke with him on the phone on the way in my car.
Okay. And did you get a history from him of what treatment he had been giving this patient?
Yes, I called him. One, I just wanted to confirm things because I was still quite shocked at the doses that were reported, and I wanted to confirm myself. So I did reach out to him, had his mobile number, and spoke with him, and he did confirm that those were the doses that he was administering, and he also confirmed that he felt that they were not working either, and he sent her to us as that. The doses were not working.
I'm sorry. Objection. Hearsay. Move strike.
The jury will disregard the last statement by the witness.
Did you receive, well, let me ask the question this way. At this point in your care of Maya Kowalski, did you have any records from outside treatment?
Not at this time, no.
Did you, for example, have Dr. Hannah's records?
No, we did not.
Did you have any records from Dr. Kirkpatrick or any of the other physicians she had seen in the preceding year?
No.
So were you basically attempting to gather information about what you were dealing with?
Yes.
And in the ordinary course of your practice, do you typically attempt to gather that information from physicians who have referred a patient to you?
Yeah, that is our typical practice, that we like to have information so we know what studies the patients have had, what conditions they've been diagnosed with, what medications they're on. Having that information is vital to our appropriate treatment of patients.
Okay. Did you Was it your understanding that Dr. Hanna had referred the patient to All Children's Hospital?
Yes.
And in the process of doing so, did he pass along to you what his treatment had consisted of?
Yes, he did.
And what did you understand?
That he had administered ketamine at large doses, as well as doses of another medicine called midazolam or benzodiazepine, another sedative, as well as clonidine.
And how did that information impact the care that you folks were trying to formulate for this patient?
Well, the care that, again, we wanted to be ultra conservative and make sure that again, our ultimate goal was to keep Maya safe and make sure that nothing untoward happened to her. And so I shared that with Mr. Kowalski also on that day. And our goal was really to get her basically safely through a period where we had some unknowns, and just wanted to be conservative and make sure that nothing untoward happened to her.
Okay. Did you participate in a meeting among the Kowalskis, the intensivist team, and the pain management team regarding the plan of care and the outlook, so to speak, for how Maya Kowalski's care would be managed?
I think at multiple times we presented kind of a multidisciplinary focus to help take care of Maya, whether it was in the room. I believe we did have a conference one day as well. But as is my usual practice, I'm very transparent and share thoughts and ideas in a collaborative effort with the family.
And did you have an opportunity to discuss Maya's condition and status and plan of care with both Mr. and Mrs. Kowalski?
Yes, I believe on the 10th it was just Mr. Kowalski, and then I believe on the 11th I met Mrs. Kowalski.
Okay. As best you can, Doctor, could you describe to us what that conversation consisted of in terms of what recommendations you made, what Mrs. Kowalski wanted to do, and what the ultimate decision was?
Yeah, I will do my best. Mrs. Kowalski tended to demand more interventions, more aggressive things such as higher doses than what we were giving, potential for intubation in light of giving those higher medications, meaning putting a breathing tube in to safely give higher doses of medicine, as well as requesting things such as implantable pain pumps to help manage pain. And I attempted to share with them some of the evidence for those things and why they probably weren't in the best interest of Maya at that time.
Okay. Let me ask you about two of those issues specifically. You mentioned the question of intubation of the patient. Why would that have been suggested, and why was it a good, bad, or indifferent idea?
I believe the context was around giving her more ketamine and more medicines, just basically to put her to sleep, to get her out of pain. And in order to do that, you have to support breathing, because the higher doses of medicines can affect your breathing, and they can affect potentially affect your heart function. So those would potentially require that to support the heart and lungs. And it's just not appropriate for CRPS to put the patient in a medically induced coma. That's not the appropriate treatment.
Okay. Did you have an opinion at that time that you shared with them regarding whether or not it would be in Maya's interest to dose her with higher doses of ketamine, such as Dr. Hanna was contemplating, and intubate her to do so?
We did not recommend that, and we're not going to offer that, and we made that clear at that time.
Okay, and why was that? Why did you not offer that?
Because it's one, there's no evidence to support that, and the standard of care does not change.
Objection, move to strike.
Overruled on that one.
And it's not safe to do that.
You mentioned there was no evidence to support that. What do you mean by that?
Well, as I shared, the standard of care for pediatric CRPS is really functional restoration, meaning that you engage the patient in the endeavors of physical therapy, occupational therapy, and cognitive behavioral therapy. The medicines are really used to facilitate those things, not for anything else.
And what are the dangers of intubation?
Dangers of intubation, one, sometimes it can be difficult to place that breathing tube. Two, it puts you at risk for other things such as infections, pneumonia, and basically patients, in order to tolerate that breathing tube, require additional medications and things that put them at risk for changes in their blood pressure, changes in the beating of their heart, and other things.
Okay. Well, what other medications does the patient have to be given to tolerate intubation?
It is variable depending on patient. These can include higher doses of sedatives, or at times, sometimes we have to give medicines to relax their muscles so they don't move their muscles to
basically paralyzed?
Yep. Yes, sir.
Now, there was a mention made of an intrathecal pain pump. Tell us what that is and what your recommendation regarding it was.
Sure. Intrathecal pain pumps are devices that are usually placed in patients, not very often in children, who are on such high doses of medicines that some of these medicines can be given around the spine so that they work more efficiently and can have lower doses. But these also entail significant risks. And at this particular, I believe Mrs. Kowalski was asking for clonidine, intrathecal clonidine pump, and those are not indicated for pediatric CRPS, and they also require basically a tube goes from the back in the spine around to an implanted pump that goes in the belly that has a motor and delivers medicine. And placing those things and maintaining those are not without risk, including appropriate dosing of medicine. You can also get significant infectious risk, especially in patients who, such as Maya, who may have immunocompromise or be undernourished. Those things would be contraindications to potentially doing that. They require a needle to fill them, and required to be filled every depending on the dose and things, 1 to 3 months. So it's not an endeavor to be taken lightly, and it's usually not used for pediatric CRPS.
Now, after your discussion with the Kowalskis first off, let me ask this. During your discussion with Kowalskis on or about October 11th, did you talk to them about all of this?
I did share with them my thoughts on the intrathecal pump. I believe with Mr. Kowalski specifically on the 10th, as well as I believe the next day with Mrs. Kowalski, and shared with him my thoughts, and the team from the week before and the weekend had kind of put the path forward, and we agreed to continue on that, meaning a slow wean of the medicines, basically to get her progressively reduced to eventually medicines by mouth.
Okay. And was there agreement to proceed in that regard?
Yes, we made shared decision making regarding that.
Were you ever aware of the Kowalskis wishing to leave the hospital against medical advice?
I don't recall specifically. I know that we talked about moving forward with attempting to, my goal at that time was to get her on medicines by mouth so that we could get her to a place that had a CRPS program at the time.
Okay, and was there in fact discussion of transferring her to another institution such as Nemours?
Yeah, I believe those discussions happened on the weekend and tail ended into my tenure on service on that Monday. Yes.
Okay. And were you ever aware of any indication that the Kowalskis wanted to leave against medical advice after your discussions with them?
No.
Were you involved in any direct communications with Nemours or their folks regarding a transfer there?
No.
Why would there be any interest in transferring to Nemours?
Nemours has an outpatient chronic pain program that they had at that time and still have today.
Okay. Now, at this point, when you were having these discussions, what was your working diagnosis with respect to this child?
So at this point, my working diagnosis was CRPS.
And was there a point at which you subsequently came to question that diagnosis?
Well, later on, as we were able to get off some of the medications and do a more proper evaluation, it definitely came to question that diagnosis, yes.
Okay, and on what basis did you question it?
Well, there were a lot of inconsistencies in the symptoms that were reported and things that were observed on behalf of Maya.
And what do you have? What are you referring to specifically?
So, in particular, there would be times where she would.
Objection, Your Honor. Is this by hearsay or is this by medical record? Objection.
Ask for his knowledge.
Yeah, can we just do legal bases overruled based on hearsay?
My direct observations at times to see some of these things. Maya complained of what we call allodynia, or light touch to her legs, and couldn't tolerate things on there at times. At other times, she would have skinny jeans very tight on her legs, which was very inconsistent and incongruent with allodynia. Would be one example of those things. Or there would be times where I would see Maya with anklets on her ankles. But if someone would attempt to touch her leg lightly, then she would complain of pain. Just very much inconsistent with the diagnosis of CRPS.
And tell us, if you would, what dates that you were taking care of Maya Kowalski during this time?
It would be hard to believe that we go on and off service over the course. So it would be time periods, probably weeks at a time. I believe maybe 3 other weeks that I might have, 2 or 3 other weeks that I might have been on service.
That was a lousy question. Let me try it again. During this particular first engagement with her,
yes,
you told us you came on October 10th. When would you have gone off service with her?
It would have been the end of that week, usually. Probably the end of that, whatever that Friday is, the 14th, I believe.
Okay. And was the pain service successful in weaning Maya off of her medications during that week?
Pretty much so. We were able to, if I recall correctly, able to wean her off. If not, then shortly thereafter.
Okay.
The IV medicines.
Okay. And were you subsequently involved in Maya's care after this?
Yes, there were periods when I was back on service as the pain doctor, as well as occasionally we cover if someone is on call at night and they're the pain doctor. If they're usually off the next day, I sometimes you may see a note for me in there because I covered for that day.
Okay. But during the period that you were initially taking care of her, were you able to make her comfortable with the weaning program that was followed?
Yes, and I worked with her parents as well, and we had continued, as you can see in my notes, agreement on the plan and closed that loop with them.
Okay. I have no further questions at this time. Thank you.
Here comes the cross.
Mr.
Mr. Anderson.
And please the court.
Glasses. In point of fact, doctor, at the time that you first saw Maya Kowalski, you had records from Dr. Kirkpatrick in evidence at 1005-10016 to 18.
I would have. I don't. May I see those?
May I approach you? I've got the list from.
Let's put it up. Yeah, let's put it up. Just a second. 0016.
And look, those glasses were not what I was expecting him to put on. That caught me off guard. Looks cool though.
I have never seen this document.
Well, your records show that it was in the Johns Hopkins records. Did you go back and actually look at all of the treatments and visits and consultations that had gone on with this child by Johns Hopkins beginning on July 7th of 2015?
Objection, lack of foundation, Your Honor. He said he's never seen it. And
Do I need to respond? I'm asking him whether he went back and looked, and then I'm asking him whether he knows when it began.
I just seen the question that you actually asked. That's all I've done.
All right. Did you look at any of the records preceding the October 7th, 2016 visit?
My routine practice is to look at the records that I have available to me and look at what I have, yes.
So is that a yes or a no?
Yes, I look at the records that I had available to me.
All right. So then those would include Dr. Kirkpatrick's records forwarded to you all after his September 23rd, 2015 consultation?
Objection.
Did you see that?
Has been established.
I have not seen this record, sir.
Okay. The Sarasota Memorial Hospital record from June 15th, 2015.
Same objection or lack of foundation.
He hasn't answered the question on this one.
This page is hard for me too.
Well, it's a fax, is it not? From August 26, 2015 to all children's?
It looks like it is. I have not seen that document.
You haven't seen those. All right. All children's, let's see, the Loyola University Medical Center from the 7, let's see, this would be from 2006 to 2011. And that is at 1005-0024 to 0046. Do you see those?
Lack of foundation.
I have not seen this document before.
Did you note any of the visits to Dr. Kreisman?
I did see some notes from Dr. Kreisman, yes.
You saw Dr. Kreisman saw Maya approximately 2 months before she went to Mexico for the medical infusions there, right?
I believe I recall that, yes.
Mm-hmm. And then you saw, I'm assuming, the visit after that, approximately 5 months later, in May of 2016. Did you not?
I cannot specifically comment. I looked at a lot of records, whether I actually saw that specifically, but I looked at a lot of records, yes.
And this was the one where, for instance, he said, this is a new child. She's happy. She appears in no pain. I can put it up if you like.
I do recall that.
Well, what other records? Did you look at Dr. Jackson's endocrinology records?
I believe I saw some of Dr. Jackman's records, yes.
Did you read the records regarding Johns Hopkins putting in the the port for the infusions of ketamine?
I believe I read that, yes.
Did you read the records for Johns Hopkins putting in the PIC line prior to that for the use of ketamine infusion?
I believe I saw that.
And did you then look at any of the notes from the endocrinologist and the prescriptions for Maya's lesions?
I believe I saw that, at some point saw those, yes.
Right. And so then, did you review then the brain scan, the MRI, in January 22nd, 2016, ordered by Dr. Jacqueline?
I don't know if I saw that one, but I saw several MRI. I know I saw another one, I believe.
I think he just said he didn't see it.
This one I don't believe.
And the Lurie Children's Hospital records?
I did see those, yes.
All right. And then the Tampa General Hospital records?
I have seen those as well.
Okay. And Dr. Wassenauer, the treating pediatrician's records?
I don't think I've seen many of his records.
Were you aware that there was a treating, that is an attending pediatrician for Maya Kowalski?
Yes, I was.
Did you have any discussions with him about the overall benefits of the protocol that Maya Kowalski was on prior to your intervention?
I did not.
So now, you are, as you sit here today, though, aware that Johns Hopkins told the Kowalskis on or about the 9th of October 2016 that they would not be able to leave, and if they did, security would be called. You're aware of that now, are you not?
I am aware of that. That's what they believe was said, yes.
Mm-hmm. And so you yourself then decided at some point to change the entire program that Maya Kowalski was on over to the Johns Hopkins program. Is that right?
No.
Did you not decide unilaterally to take Maya Kowalski off of any ketamine, off of the medicines prescribed by Dr. Hanna, and before that Dr. Kirkpatrick, and before that Dr. Cantu?
My priority was the safety of Maya, and I expressed that with her parents.
I understand. And by safety you mean, was she displaying any signs of physical harm, right?
I'm not sure I understand your question.
Well, when you say her safety, you're not talking about her safety in the next 20 years or 10 years or 15 years. You're talking about her immediate safety, are you not?
We were talking about the amount of medicines that she was getting and potential for withdrawal, other complications from those.
I see. And so it is true, is it not, that ketamine has limited, if any, withdrawal symptoms?
Ketamine can be associated with withdrawal. It is limited compared to some of the other medicines, but you can have some withdrawal. But our other concern was with some of the other medicines that she was getting.
The fact is that there are no studies outside of those that involve street ketamine that show any physiological withdrawal symptoms from ketamine.
Objection to proper impeachment.
Sustained.
Are you aware of any data indicating
the data that is out there?
I will withdraw on that one. So now you are worried then, I guess, when Maya came in about her health. And so what steps did you take to ascertain whether she actually was having any negative responses to the program that was already in place?
So I was not on service when she first came in. We continued the plan that was in place. So I'm not sure what your question is then otherwise.
Sure. If Maya was going to have some problems from the dosing of the medications, most likely it would be in the liver, would it not?
Ketamine can cause several things. It can cause neuropsychiatric problems. It can cause problems with the kidney and the bladder, as well as with liver.
Did you or did you not do any blood work on Maya Kowalski?
I did not personally order blood work.
did you ever review any blood work on Maya Kowalski over the course of the first 2 weeks?
Yes, sir.
And her blood work came back all within normal range, did it not?
I believe so, yes.
So your concern then was for the future. How long had Maya been on the regimen that you took her off? Or maybe not you, but Johns Hopkins took her off.
It looks like that she had received approximately 50-some treatments prior to us.
All right. And over that 50-some treatments, she had never once complained, at least in the medical records, about any withdrawal symptoms. Is that true?
I don't recall that, yes.
From the history that you took, did anybody ever say on the various intervals between ketamine treatments that Maya Kowalski complained of anything like withdrawal symptoms?
Well, if you look at the presentation that she came with, agitation, she had nausea, she had anorexia, as well as motor disturbances, all can be related to ketamine, as well as potential for some of the other medicines that she was getting led to potential significant constipation that she had.
What she had was a condition known as gastroparesis. True?
I did not see that documented.
Mm-hmm. Gastroparesis is, well, explain to the jury what gastroparesis is.
So gastroparesis is where the motility of your stomach is decreased.
And it can manifest in a number of different ways, isn't this true?
It can, certainly.
Yeah. And one of those ways is what? By nausea?
It certainly can.
And constipation is a constant one.
Gastroparesis has nothing to do with constipation.
And general unrest there? In the gut, that is.
I'm not sure I understand what you mean by that.
Well, the point being, if you are familiar with CRPS and its diagnosis, you are aware that gastroparesis is one of the complications of CRPS.
Objection foundation, Your Honor.
Overruled. You can answer that.
There is no association in pediatric CRPS with gastroparesis.
Well, let's just say maybe not pediatric, but in CRPS, the disease, gastroparesis, is a known complication. True?
No.
Right. So she'd been in less than 6 days before with the identical symptoms, right?
Yes.
Okay. And at that point, nobody decided to take her off of all of the medications and admit her into the hospital. Correct?
It looks like what's happened, yes.
All right. But this time, the decision was made, I guess, to admit her and change her protocol, right?
I believe she was definitely, I wasn't there during that time. I can't comment on that.
Well, this time you can, though, and you can comment on what she was taken off of and what she was put on. Isn't that true?
I can share with you some of those things, yes.
Sure. One of the first things that she was prescribed was Haldol. True?
I believe she was given Haldol at some point, yes.
Tell the jury what Haldol is.
Haldol is a medicine that is used for various reasons, but agitation is one of those.
It's a powerful antipsychotic, is it not, Doctor?
That is one of its effects.
So one of the first things that the Johns Hopkins doctors did was take Maya off the ketamine and put her on an antipsychotic. True?
That was used for refractory agitation when other things did not work.
Right. Did you put her on Haldol as you were taking her off the ketamine?
I don't know if I wrote for that specifically or not, but that was in part of the treatment plan that we discussed.
And you put her on Tramadol. True?
Tramadol was one of her home medications that we continued.
Right. That's an opioid.
It's opioid and agonist-antagonist.
And when she came in, she had no opioids in her system. True?
I don't recall one way or the other.
And you put her on Ativan. What's Ativan?
Ativan was one of her home medications.
What is Ativan?
It is similar to midazolam. It's a sedative.
All right. And Valium, same thing. Those are both benzodiazepines, right?
Yes.
Okay. So whether you put them on or whether you continue them on, Maya is now having had opioids and benzodiazepines, no ketamine, but Haldol. True?
Those were some of the medicines that she was on.
Okay. Now, you put her on Haldol, or I don't know if it was you, but surely you had a pediatric psychiatrist that was involved at this point if you're using antipsychotics, right?
We use it for agitation as well as nausea. There are other reasons to use it besides its antipsychotic properties.
Did you prescribe, either you or someone on your team, an antipsychotic without an evaluation by a pediatric psychiatrist as to its effects?
That would not be a standard that routinely occurs.
I'm not sure I understand. Is that a
if we're
yes
giving
or no?
something for agitation, especially in the intensive care unit, we do not necessarily get psychiatry involved in that.
So the answer is yes, you put her on an antipsychotic without a pediatric psychiatrist looking at it.
Well, I
right?
believe that psychiatry was refused most of the time.
All right. And so, Dr. Katzenstein saw her, right?
She's not a psychiatrist.
Dr. Cabot was, and he saw her, right?
Eventually he saw her, yes.
Right. All right. So at the time this all started, you were on vacation.
Yes, sir.
And when you were called, you were actually in your garden. Out back, were you not?
I believe I was in my yard, yes.
Right, okay. And Dr. Dolan calls you and tells you about a dosage of this medication, of ketamine, right?
Mm-hmm.
And you say, that sounds high, or worse to that effect.
Yes, sir.
At that point, you did not know whether it was in, and what is a bolus, by the way? What is a bolus versus an IV, an infusion?
So a bolus can be very things, but it's usually given faster than an infusion.
Okay. And so at that point, she did not describe whether or not Maya was getting all of these, the amount of medication related to you in one bolus as opposed to an infusion. True?
I don't recall the specifics that were told to me.
Well, there's a big difference, isn't there, between putting it all in at one time and an infusion over several hours?
It depends on the total dose.
Mm-hmm. And the total dose is determined by titration, is it not?
Total dose in pediatrics is based on weight.
Okay. And if you're going to infuse it, you titrate. True?
Depending on the reason.
All right. And if the reason is pain cessation, then you would titrate, would you not?
To limits, yes.
Right.
There are limits.
Okay. And in this case, who was best to determine those limits? The physicians who spent all of their time on CRPS pain patients and were actually part of foundations determined to do that, or you guys?
Well,
argumentative, John.
Yeah, sustain the argumentative.
Well, are you a member of the RSD Foundation?
No.
And you do not specialize in CRPS, do you?
There's no specialty in CRPS.
I understand, but you have published no papers, correct?
Not yet. That's correct.
And you have not participated in any studies, correct?
That I don't recall.
Right. You have given no talks, no lectures on CRPS.
No.
Nor have you given any particular studies or lectures on the use of ketamine to treat CRPS. True?
That is correct.
But you, Johns Hopkins, had determined that whatever was going on out there, whatever was going on with those other doctors, you guys knew better. True?
Argumentative, Judge.
Ruled on that one.
Is that true?
No.
I see. So it was a mistake. You guys were actually going to stay with what was...
We were providing evidence-based care that we were comfortable with for pediatric patients.
Do you recognize as authoritative the consensus guidelines for use of intravenous ketamine infusions in chronic pain by the American Society of Regional Anesthesia and Pain Medication?
Yes, that is a guideline. Uh-huh.
And have you reviewed any of their papers there?
I have looked at that, yes.
And would you agree with me that they're based on their papers, and I can show this to you if you'd like. There is, at volume 43, number 5, the July 2018 paper that provides significant support for the use of ketamine, large dose ketamine, to treat CRPS.
Up to 7 milligrams per kilo, yes.
Okay. Now, in terms of what the ultimate load was, the ultimate amount, are you familiar with what a P450 enzyme is?
Yes.
Does a P450 enzyme break down ketamine?
It is part of the mechanism for which it is broken down, yes.
And is that P450 enzyme a result of the use of prednisone or others of that type?
I'm not sure I understand your question.
P450 enzyme will extended use of prednisone and other prednisones of which family again?
Steroid.
Other steroids will cause P450, the P450 enzyme in fairly high amounts.
It can do both. It can either upregulate it, but it also, you don't really know, it could also downregulate that enzyme.
All right. But you did not take that into account when you were trying to determine how much, right?
I'm not sure I understand your question.
Did you do any independent studies or any evaluation of where the latest literature was on the use of this type of treatment, that is, high-dose infusions of ketamine to alleviate pain in CRPS patients?
Yes, we did. We looked for literature and did reviews, yes.
Right. Your own literature, though, inside.
No.
Well, did you talk to Dr. Kirkpatrick on his papers?
I did not speak to Dr. Kirkpatrick.
Well, did you talk to Dr. Hanna on the reasons why he chose those amounts?
I spoke with Dr. Hanna, and he told me his amounts were not working.
Right. But not because they were ineffective totally, but because he had reached a limit to which he could go safely without intubation. True?
He told me they were not working.
Not because ketamine doesn't work, but because he had reached a limit to do it
He did not tell me
outpatient.
that.
He's saying he did not tell you that? All right. All right. So now, in your evaluation then, and let me get this straight. Does Maya Kowalski have CRPS or does she not have CRPS?
What do you mean?
That's a pretty straightforward question.
So if you
Does
read my,
Maya Kowalski
if you read my
have a
notes,
proper diagnosis of CRPS or does she not?
if you read my notes, I never rule out CRPS.
Okay.
However, it is less likely given her clinical presentation and the inconsistencies, some of which I had already shared.
Well, she certainly meets the epidemiology profile, does she not?
She has some of those traits for both of those disorders, yes.
Well, she was 15. She was female, adolescent, right?
Mm-hmm.
She had epidemiologies. Yeah. Oh, yeah, every time. Well, hang on.
Anderson's close to about 45 minutes of time he's burned today on cross-examinations.
2017-754. And let me ask you, doctor, over this period of time, were you billing for CRPS?
What do you mean? You're asking for billing codes?
Well, I don't know that you need them here.
Okay.
Were you billing over this period of time for CRPS?
Yes.
Boom.
Can you bring up 2017
We did that already.
Excuse me, Your Honor, that's a partial answer to the question and a partial question that was asked. He was the judge. In other words, the document speaks for itself.
Overruled. You can continue.
Thank you. 2017-762. All right. Were you billing for CRPS over this period of time?
Where are the dates on here?
I'm looking right now. Date of service, December 2nd, 2016.
So these are diagnosis codes, not billing codes?
Okay. Were you billing for complex regional pain syndrome treatment over this period of time?
I would have to see, I'm assuming so, but this is a diagnosis code.
All right. Yeah. That's all I have time.
Okay, he got reined in. That's all he has time for. That's 24 minutes spent on this witness. He doesn't have 24 minutes to spend on any witnesses.
Mr. Hunter?
Yes, sir. Could I ask that 2067762 be left up for a moment?
That was not 20. That was 2017. Is that what you want?
Yeah, whatever you had up there, I thought it was.
Put that back.
The billing run. Yeah.
I think it was 06.
I had 2067762, whatever it is.
There it is.
Okay. Could we put that nice little red ring around all the diagnostic codes, not just two of them? All the way down. So we've got here the diagnosis code is chronic pain syndrome, correct?
Yes, sir.
Pain unspecified, correct?
Yep.
And then we get to complex regional pain syndrome of lower limb bilateral.
That is correct.
And then we have complex regional pain syndrome unspecified.
Yes.
Were all those codes being billed under?
Those are all diagnostic codes, yes.
Okay. Not just complex regional pain syndrome?
That is correct.
Okay. There were some questions asked about the medications that this patient, well, let me strike that and back up. Counsel asked you about the consensus guidelines.
Yes, sir.
You indicated you were familiar with those.
Yes.
Now, when were they published?
Those consensus guidelines were published in 2018. They were not available during the time that Maya was in the hospital.
Okay. So they were published after all this?
That is correct.
Okay. And based on the evidence that was available to you folks, were you able to find any evidence that indicated that it was efficacious in the treatment of pediatric CRPS to give a patient 1,250 milligrams at 25 kilograms of weight over 2 hours?
No, we could not.
Have you ever heard of such a thing?
Never.
Is there anything?
And hearsay.
Is there anything in the literature that supports this?
No.
Objection.
Sustained.
Move to strike.
Court will disregard the last question and answer.
Is there evidence, are you aware of evidence to support the idea that that level of ketamine is safe for a child?
Objection. Holstering.
Sustained.
Counsel asked you whether you had published on CRPS. Have you published on pediatric pain management?
Yes, I have, and I've been involved in talks and workshops at national meetings, all relative to pediatric pain.
What is the incidence of CRPS in the pediatric population?
It is quite rare. It's approximately one child per 100,000.
So would it be reasonable to think that someone could develop a specialty in the treatment of pediatric CRPS alone?
No.
Why is that?
There's not enough cases.
The counsel was asking you about the medications that you folks, that were given to this patient when she presented to the emergency room. You weren't there.
That is correct.
Why would the patient be given Haldol and the other medications that were specified?
A lot of those, we worked in collaboration with her parents and discussed a plan, and that was all documented. We were trying to balance her comfort with agitation and weaning of the medications.
Did you go back and look at the records from her visit to our ER on October 1st of 2016?
I believe so, yes.
Did she indicate the level of agitation that she did when she presented on October 7th?
No.
Was there any indication of a chronic pain crisis on that day?
No.
had she been referred, according to the records, by her treating CRPS doctor to All Children's on that day?
Not that I recall.
Okay. And what was the occasion for her reference to All Children's on October the 7th?
Can you clarify that question?
Well, why was she referred there?
She was referred there from Dr. Hanna, I believe.
There was reference to some medications that the patient had at home. That included tramadol?
Yes, sir.
In other words, had she been given tramadol by outpatient physicians?
Yes.
Not by All Children's?
That is correct.
Had she been given Ativan by outpatient physicians?
Yes.
Is gastroparesis associated with ketamine?
Ketamine can impact multiple receptors in the body, including opioid receptors, which do have implications for slowing down gut motility. Yes.
We've been talking about the extent. Well, let me back up a minute. We talked earlier about what records you had available when you saw this patient when you came on service. Counsel showed you several records. Were any of those available to you at the time that you first saw this patient?
They were not available to me that I recall.
Okay. And at the time that you first saw this patient, did you have any records available from either Lurie's or Tampa General?
No.
Why were you concerned about the ketamine doses that Dr. Hanna described to you?
Ketamine can have numerous side effects. She had already had a history of elevated liver enzymes, I believe, in the past, and then she was getting these large doses of ketamine. Ketamine is also what is called an NMDA receptor antagonist. And in developing brains, it has been shown to potentially cause brain cell death and brain damage. So that, along with the reported magnesium that she was getting and the large doses, very large doses of dextromethorphan that she receiving, all were NMDA receptor antagonists. So our concern was the potential impact it may have on her brain.
We talked earlier about conversion disorder and patients feeling pain and not necessarily telling them that it's in your head or they're faking it. Mm-hmm. In the treatment of these chronic pain syndromes in pediatric patients, do you folks take their complaints of pain seriously?
Yes, we always believe our patients. That's what I tell them when I first meet them, that we believe their pain is real.
Was there ever any point that you're aware of at which Maya Kowalski was told that it's all in your head or it's fake?
Nothing that I ever said to her.
Okay. And were you ever aware of her being told that her mother had put her in a coma or was in a psych ward?
No.
That's all I have. Thank you.
Anderson, stay seated, please.
Mr. Anderson, do you agree or disagree that the Kowalskis knew what was best for their own daughter's treatment?
I'm not sure I understand.
Overall, do you agree or disagree that Jack and Beata Kowalski knew what was best for their own child's medical treatment?
Well, I think that after reviewing the medical records and realizing that several other institutions shared with them the diagnoses.
Objection. Go ahead.
Shared with them the diagnoses included conversion disorder, and that the treatment was psychology, CBT, PT, and OT, and yet they continued to seek aggressive interventions was very concerning to me.
So the answer is, if I'm understanding you, correct me if I'm wrong, you think you and Johns Hopkins know better than the Kowalskis how they should have their own child treated. Is that true?
That is not what I said.
I'm going to sustain the objection.
I have concerns.
Same objection, Your Honor.
Okay, we understand objections. The question is, as between the Kowalskis themselves and Johns Hopkins, who had the right to make the ultimate decision on how they treated their daughter?
Objection, Your Honor. Argumentative calls for conclusion.
Sustained.
Legal people. Did you believe you knew better than the Kowalskis on how to treat their own daughter?
Argumentative, Judge.
I'm going to sustain the yes and answer, so how about that?
And so, was it true, and is it true, that the Kowalskis had the right, under the Johns Hopkins own patient statement of right, to reject your treatment?
They certainly could.
Anything further, Mr. Hunter?
No, sir, Your Honor. Not at this time.
So we're on to the jury questions. Jules is in position, ready to get her notes. 4, 5, 6. She's
Do
looking
not
at the
discuss
jury
this
numbers.
case amongst yourselves. Do not do any investigation and receive no information.
All right, jurors exited.
Okay, I'm struggling to get this feed going here. Give me just 1 second. Hey guys, we have a big crowd in here, and our mods are working overtime trying to keep this nice. If you can't keep everything talking about the issue at hand and do it in a respectful way, I'd ask that you just save your comments for another time, if that's all right. Our mods are being worked overtime, and I can't expect them to catch every single comment as it goes by. You guys know what's good and what's not, so don't no attacking the witnesses. Let's just be respectful of everybody's time, okay? Okay. Trying to hear these questions here. Okay, I just came into here. No objection from Mr. Anderson on that one. Sorry, I missed one. Mr. Hunter says object to that. Red number 2. How was it, in your opinion, possible that Maya could be getting such large doses of ketamine and still be awake? Next question. If these levels of question are unheard of, why are known doctors and CRPS able to use these levels? Kathleen, we're trying to get that squared away. It's not normal. We've got a big crowd in here. We're trying to fix the troublemakers. Thank you, though. Red number 3. You mentioned you were able to wean Maya off of many of her meds over weeks with the parents' agreement. Were they cooperative with that plan? Ketamine was being weaned, but one medication you added was Halbal, an antipsychotic with sedative qualities. What are some of the other known side effects? No objection on either side. Red number 4. Did Maya have with... Judge is trying to decipher what it says. did Maya have blank after receiving a high dose of ketamine? He's asking them to withdraw. Did Maya have withdrawal after receiving a high dose of ketamine? Judge says, oh, for those two words, that makes sense now. Read page number 5. Was the hospital, all children's hospital staff, trained on CRPS before 2016 when you took over? Next question was scratched out. Was Maya a reason for J. Hatch changing the way they treated CRPS? They say Mr. Hunter objected to the last one. Mr. Anderson, there's no proper reason for that. Talking about the objection. Mr. Hunter says it's already come in several times over objection. Judge says I'm going to sustain that one. So besides the one I just sustained, any others, says the judge? I'm listening to the court Zoom feed, which I'm not allowed to let you listen to directly or watch, but I can recount what I hear on it. That's why I'm able to hear the sidebar. And it's not every sidebar I can hear. It's just the jury, just these, the little conversations they have up at the bench about the jury questions. Judge is writing something. It's very quiet in the courtroom right now. Yeah, so I can only hear when the jury and the witness have left and they don't have that white noise machine turned on. And the Zoom went down. See if we can get this one more time. I guess nobody's talking. That's why it's just quiet. Oh. Mr. Hunter says we object to number 5 because, frankly, I don't understand it. And I object to number 2 on the basis of the fact that it seems an example, and I'm not sure that's they're sort of talking over each other right now. I heard no objection from Mr. Anderson. They're looking over the whole list, talking about objections. So, Mr. Hunter, number 2, you're talking about this question right here. So you're okay with the stuff down there? Mr. Hunter says, I'm objecting to the example. They're objecting to part of the question, not all of it. Several people talking again. Mr. Anderson says, I don't have any problems with the examples if he understands that it's possible the juror might know of a drug that all of us counsel did not know about. Judge says, I'm going to go ahead and sustain as to those two, 1, 2, 3, 6 lines on number 6, but with this example, I'll start asking there with respect to I don't understand 5 enough, so I'll sustain the unintelligible objection from the defense. So moving on to red number 7. Are you saying that diagnostic codes do not need to match the billing codes that is sent to insurance companies for payments? Next question. You can give a man a vasectomy a bill for a hysterectomy, and that's acceptable practice? That's what they wrote. Mr. Hunter says it's argumentative. And it displays, once again, a level of bias that is disturbing. Mr. Anderson, it's not bias. It's an example the juror is trying to bring down to the level that he or she understands. And this was clearly, says Mr. Anderson, the goal of the redirect was to establish what the jurors, something questioning. The judge says, well, considering that this case is not about vasectomies or hysterectomies, and they're laughing. Is there another motion to amend coming? Says Mr. Hunter, jokingly about adding those in. Just so the transcript's clear, the judge says, we have multiple issues of laughter, which is good to hear. I'm going to sustain the objection as to number 2. This vasectomy hysterectomy question is not relevant to the case that we're here for. Judge says, I have a very small something view that this ever becomes relevant in this case, Mr. Anderson. Judge says, okay, is there going to be another witness after this witness? Correll says, we have depositions that could be played depending on the timing. Judge says, how long are the depositions? Correll says, one is 16 minutes. Judge says, well, let's get that queued up. See if we can get that done before 5 o'clock. Debbie Walford. Judge says, let's bring in the doctor. Let's bring in the jury. Mr. Hunter is sniffing his notepad. I'm not sure what he's doing. Oh, okay. Here we go. Okay, jury's coming back in. Sorry, it's getting increasingly difficult to hear those. I'm not sure if they moved the microphones or what, but it's difficult to hear those people, so it's hard to bring it verbatim what happens on Zoom. Let's see. Recovery Addict. Here forward, can you highlight Jules and Law and Lumber comments? I don't read chat to avoid triggers when there's so many new members. I hear you. Listen, learn. It's a hard thing for me to pick out all the chats. I try to catch Rob's when I see him because almost always they are extremely insightful and timely. I haven't found an objection to that yet.
Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct?
And you did not see any media coverage, is that correct? And no one approached you, is that correct? And we reviewed these questions outside of the doctor's presence. Dr. Elliott, the jury has a number of questions, so I'm just going to start reading. You testified your protocol is pre-anesthesia level, not to exceed, I think you said, 2 to 3 milligrams per kilogram per hour of ketamine. We have heard testimony that Maya received 5 milligrams per kilogram per hour of ketamine at All Children's. Why would All Children's go against their protocol, and is it documented in her medical record as an exception?
Yeah, so those doses are a little bit not correct. Our pain protocol is 0.2 to 0.07 to 0.2 is our range, up to 0.5. The dose that was decided on, again, I wasn't there at that time, I believe was a compromise with trying to balance what she had received before with some of the whatever evidence we could find at the time, and working with her parents at that time to try to come up with something to help her, and something that we were comfortable with based on the clinician's judgment at the time.
His microphone's off.
What was the dose of Haldol Maya was receiving, and how often was it given?
I don't want to guess. I believe it was 1 milligram, and I don't recall. It was probably every 6 or 8 hours as needed.
The next question, what was the route in which it was given?
I believe it was ordered intravenously.
Next question, how was it, in your opinion, possible Maya could be getting such large doses of ketamine and still be awake?
I know that there were times that she wasn't awake, given that. So that would be hard for me to answer, because I really did not see her right after those doses to give an appropriate evaluation of seeing her after she received those doses with Dr. Hanna. I was not there.
Okay. If these levels of ketamine are unheard of, then why are known doctors in CRPS able to use those levels?
This is a topic of controversy right now, the growth of ketamine clinics in the U.S., and it is not officially regulated. They are not regulated by the FDA and the government at this time. And so people use things off-label, and so there's no regulation by the government of this, although there's talks of that happening.
Off-label means not for its intended use.
The next question. You mentioned you were able to wean Maya off of many of her meds over weeks with her parents' agreement. Were they cooperative with that plan?
With me, most of the time, I am very honest with that, and I believe that I had a reasonable relationship with Mr. and Mrs. Kowalski. I was honest with them, and we attempted to work with them to have a plan that we could mutually agree upon, and I believe that's demonstrated in my notes in the record as well. And I tried to, as with all my patients, work together, engender their trust, and make them understand that I treat their children as if they're my own children.
Ketamine was being weaned, but one medication you added was Haldol, an antipsychotic with sedative qualities. What are some of the other known side effects
of Haldol?
Of Haldol.
Okay. So Haldol in large doses can potentially impact how your heart beats. It can also cause abnormal movements. Those are probably some of the two bigger things that can happen with it.
Did Maya have withdrawal after receiving the high dose of ketamine?
It's hard to say. Because we had put her on medicines to help withdrawal, that, for instance, that infusion of the dexmedetomidine is used to help ease withdrawal symptoms. So it's very hard to say if she had withdrawal or not because of that medication being on board. And that was the point of that medication, to make sure that we did not want her to suffer any withdrawal from some of the medicines that she was on.
Was the All Children's Hospital staff trained in CRPS before 2016 when you took over?
I'm not sure what's meant by that question per se. At that time, we were working on building an outpatient program, an outpatient clinic, as well as a CRPS program. At that time, we had a couple of inpatients with CRPS, so people were familiar with it, although we didn't have a formal program at that time. So people are, in general, familiar with it. In terms of the pain team, everyone was familiar with it. And its treatment in the pediatric realm.
And I cannot ask that next question. Dr. Elliott, in 2016, it appears ketamine is not your preferred form of treatment for CRPS. You mentioned more along the lines of 2 types of therapies to use for CRPS. Is this a correct understanding on this juror's part?
Yes. The standard across the country for pediatric CRPS at children's hospitals is physical therapy, occupational therapy, and cognitive behavioral therapy. Some of those institutions use those things alone. Others, like we do, use adjuvant medications to help facilitate, meaning pain medicines to help facilitate the physical therapy as needed.
Do you now see, as more research has been conducted, are you more open to ketamine as having a place in a possible treatment for CRPS in amounts larger than what you were accustomed to in 2015?
I think as those guidelines share, and if you would read them further, they talk that there needs to be more data. Those guidelines are based on very poor data. There's a way that you rate studies based on their quality. And most of those recommendations there are based on very poor level of quality. There's very few studies, even by people who claim to be CRPS experts, that are of any good size, none of which really are in pediatrics, to validate the use of that. And the data really shows, and these studies and the guidelines, that there is no benefit to ketamine beyond 3 months. And that is what is emphasized out there, and that is still what is described in especially the pediatric realm.
Have you ever been involved in medical research to find cures for illnesses using established or new drugs?
Yes, I have been involved throughout my career in trials for different avenues of medications or things, vaccine trials, as well as other medications. Yes.
Are you a doctor that follows only set and/or approved treatments for a known illness?
I think all of us use those as a foundation for the treatment of diseases. Do we look beyond that and look at each individual patient? Yes. Balancing, safety of treatments with outcomes in that regard. And so, especially in pediatrics, we have to be much more mindful of things because of the varying changes in body chemistry, and what we call physiology based on age is very different than in adult patients. So it's harder to do some of those things and go outside of that scope with pediatrics. Some of that is protected on state level. For instance, in Maryland, it's very hard to do drug studies on pediatrics because of the laws protecting children, and I experienced that when I was in Maryland.
Are you saying that diagnostic codes do not need to match the billing codes that is sent to insurance companies for payment?
So I don't claim to be an expert on diagnosis and billing, but usually for patients, There are submitted what are DRG codes or ICD codes, excuse me, is the newer term, and then CPT codes, for lack of it, which are billing. So there are 2 codes. A lot of that is determined by hospital billers who are expert in this based on the stuff that is in the note. We don't always assign that. We usually assign diagnoses of which we may have made or other people may have from their past medical history. So a list of diagnoses, and now in more modern medical records, we have kind of active diagnoses labeled and by historic, which we didn't always have in the past. So we try to be more of that, but we try to be all inclusive as well, so that when other providers are able to look at the record, they can see that at least was in the history, and take that into consideration when kids present with things.
Those are all the jury questions. Mr. Hunter, do you have any follow-up?
No.
And Mr. Anderson, any follow-up?
As we sit here today, you have no data showing systematic harmful effects of the use of ketamine in treating CRPS. True?
There is data on CRPS, on ketamine and potential neurotoxicity in children.
Only for children. That study is for children under the age of 3. Isn't that true?
It's not a study.
Proper impeachment, Your Honor.
Overruled. You can answer.
It is not a study. The official FDA communication is for children now potentially 5 and under, but they also claim that they do not know. We do not know that the brain is developing up until upper teens.
Was Maya 5 and under at the time?
She was not.
Anything else, members of the jury? I don't see anyone writing. May this doctor be excused?
Yes, Your Honor.
No objection.
Okay, Dr. Elliott, thank you for being here. Members of the jury, we have a 16 or 17-minute deposition that we're going to play now, which should take us exactly to 5 o'clock. Do you want me to dim the lights or just leave the lights as they are? Leave them on?
The fact that the jury can come to a consensus there is an interesting point.
It's the deposition of Dr. Walford.
I don't hear a lot of leave them on, turn them off. Leave them on, turn them off. Here we go.
Raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Doctor, can you tell us your name, please, for the record?
Mary Elizabeth Terry Walford.
Okay. And what is your occupation?
I'm a pediatric surgeon.
Where do you presently practice your profession?
The name of our practice is Gulf Coast Pediatric General Surgery, and we practice at Gulf Coast Medical Center.
And where is that located?
Panama City, Florida.
How long have you been with Gulf Coast in Panama City?
Just over 4 years.
And prior to that, where were you?
I was at Johns Hopkins All Children's in St. Pete for 8 years, or almost 8 years.
Could you tell us, Doctor, where you received your undergraduate training and when you graduated?
Yes, I did my undergraduate at University of Georgia. I was there from 1994 to I graduated early at the end of 1997.
Okay. And where did you go from there?
I went to medical school at Mercer University from 1998 to 2002.
And you graduated from Mercer?
Yes.
Where did you go after you did with your MD from Mercer?
So I did my internship and residency in Savannah, Georgia at Memorial Hospital, which is part of Mercer University.
And that was both. What can you tell us? Tell us about your internship and residency?
Yes, that was in general surgery, and then you have to finish general surgery before you can be a pediatric surgeon. So I did general surgery there, and then I did my pediatric surgery fellowship at the University of Oklahoma in Oklahoma City.
Okay. And when did you complete your fellowship training? 2010,
and I went straight from there to All Children's.
Okay. Are you board certified?
Yes, I'm board certified in both general surgery and pediatric surgery.
Could you tell the jury what that means?
Yeah, so in order to be board certified, you have to finish a residency and pass for general surgery and pediatric surgery, both written and oral board certification exams. And you have to maintain those certifications by completing case logs showing the work that you've done in CME every year. The old system, which I'm still accredited through general surgery, involves a comprehensive test every 10 years, but they've changed it over to a CME and case log system now. So that's how I've maintained my board certification in both.
During the time you were practicing your profession at Johns Hopkins All Children's, did you have occasion to see a patient by the name of Maya Kowalski?
Yes, I did.
Okay. Do you remember her?
No.
Have I provided you certain records regarding certain records that you created when you saw her at Johns Hopkins All Children's?
Yes.
According to the records, how did it come about that you saw her?
So she was a patient who I saw in the office or clinic, if you will. She was scheduled through our office after she had, I assume, a referral from the referring physician. That's how we see patients. They come with referrals because we're not a primary care situation. They come from another physician, basically.
Okay. What was the purpose of the referral of Maya Kowalski to your practice?
Basically, she was referred to get a port placed.
Okay. And what is your role as a surgeon when a patient is referred for the placement of a port?
So as a surgeon with ports, we are basically mechanics. They ask us to do a job and we do it. It's not something where we treat patients other than putting in ports and ensuring in good faith that someone is going to take care of those ports, flush them, do the random maintenance that needs to be done.
In the case of Maya Kowalski, what history did she give you upon presentation? Or what, I should say, what history were you given upon her presentation?
So based on my review of the records from my office, that she had a diagnosis of RSD and needed the port for ketamine treatments and blood draws.
Were you familiar with the physician who referred her to you?
No, I wasn't.
Is that fairly typical in these situations?
Yes.
Did you ever consult with the referring physician, in this case, Dr. Hannah?
No, the only thing we do is our office automatically generates a letter back to any consulting physician with the plan and basically our office note from that day.
Did you undertake to evaluate or confirm, or for that matter, comment on the diagnosis of RSD?
No, in fact, I barely know what it is. It's not my job to diagnose something that's out of my realm of knowledge.
It's not my job counter.
Did you consult with Dr. Hannah or any other doctor for that matter regarding the treatment regimen for RSD?
No. Your question is, why did I not consult with someone about this treatment?
Yes, ma'am.
It's way out of my realm. If somebody comes to me that needs a port for cancer or whatever, I'm not going to say, first of all, I don't think this patient has that cancer or has a different cancer. And I'm not certainly going to say, well, this patient should be treated with radiation and not chemo. It's every physician has a different job in the management of complex patients. And my job is to put in a port when someone orders a port. It's not to second guess or change the treatment that a patient's undergoing.
Were you successful in this case in placing a port in Maya Kowalski?
Yes. Did
you ever see her again after that?
Not to my recollection. Sometimes we do post-op visits, like a patient will have an office appointment 2 to 4 weeks after a procedure is done. It's not routine for ports because usually those patients are already in the system seeing other physicians. And I haven't seen a note that I did. So I assume that I did not, but I can't say 100%.
Did you have any occasion to consult with any of the other physicians practicing at Johns Hopkins regarding Maya Kowalski?
No, the only conversation I would have had is, and and I don't remember anything, but during a procedure, and I even saw my order speak with anesthesia about if the patient needs like a pre-medicated steroid for surgery. We discussed the history with the anesthesiologist as we're going to the room, but not really. It's more just like, do we need to do anything specific for this case? It's not about her overall condition or treatment.
So would you have been discussing with them any overview or oversight of the RSD diagnosis?
No.
Here, obviously, it says there's a sticker for Monica Kowalski and your name, and then it says 020316. And then under chief complaint, what is that? Is that eval port placement?
Mm-hmm. Yes, that's what our office staff writes down for the reason why the patient has come.
What is an eval?
It just basically means to see if it's something that we can do.
What are you looking for there?
Several things. One of them is a history of what lines the patient has had in the past and whether or not we need to work them up for clots in their venous system that might have a problem with putting ports in. Another thing is evaluating their chest wall based on the age and size of the child, whether or not they can fit a port on their chest wall. Those are the main things.
I got it. That's fair enough. Okay, let's go down to new problems. Can you translate where it starts with what I think is a W, or it could be an L/O, or
history of RSD?
That's history.
HO, history of.
Okay. And for the benefit of the jury, is that the same thing as CRPS, complex regional pain syndrome?
So I have that in my past medical history right there. My guess, because I've never heard of CRPS before or after, is that whoever was providing the history told me that.
Got it. All right. Since that time, are you aware that RSD is an older term for CRPS?
Only because of this case, someone told me that over the phone.
All right. Now, underneath that, needs port.
Mm-hmm.
Is that what it says?
Yeah, it says needs port, frequent ketamine infusions, IVs, blood draws.
And have you, strike it, I gather you have done more than one port placement in your career.
Yes, hundreds.
Right. And
if not thousands.
What is the typical, if there is a typical, reason for a port placement?
There is not a typical reason. Usually it's some sort of infusion or patient with poor access that needs access for either infusion or blood draws. I would say the most common reason is for chemotherapy, but certainly there's no typical reason. We place them for other reasons as well.
Have you placed a port for RSD or if not that, then long-term chronic pain patients to receive medication before or after?
Not that I recall. But for patients with chronic conditions that are in and out of the hospital multiple times.
Well, the purpose of the port then is to receive medication and or fluids generally?
Yes, or frequent blood draws for patients that are very difficult sticks.
Okay. And in the
difficult stick has to do with the needle for drawing blood.
Ketamine infusions. Is that your handwriting, by the way?
Yes, it is.
And where would that information have come from?
Whoever was providing the history, the family member, I assume the mother.
Oh, there you go. Now, is part of your pre-surgical preparation with the patient, if it is known that they've been treated at All Children's previously, to review the medical records, at least from Johns Hopkins?
No, and as a matter of fact, I'm not sure from a HIPAA standpoint about access to old records. That would be a good question for you guys. Actually, I don't know the rules about that, but usually I only look up the patient's information if it came from the referring, whatever the referring physician might have sent. But I usually don't dive into other things unless there's some reason. For instance, she told me she had lots of central lines placed before with scar tissue and problems, then I may look up old studies related to that, but I would have no reason to dive into her medical record unless it pertained to what I was doing.
So was it, at least in your part of the pediatrics specialty, a common or accepted procedure to rely on the patient's description of the history in determining what treatment you were going to initiate?
Well, I wasn't going to initiate any treatment.
I understand, to the extent putting in a port is a treatment, but.
Yes, basically the family provides the history and the physician provides an order for it. The family can't come in and ask for one without a physician's order.
Got it. And then the next paragraph.
Maya and her mother are very specific about where they want the port placed. They want it in a cosmetic location, probably on the lateral chest wall in the lower bra area.
Nothing unusual about that, I would take it.
It's not a great place to put a port, honestly. And so if they ask for that, we try to make a note of it because we will not put them there routinely.
Why is that?
Because it's a longer tunnel for the catheter to make, and they often become kinked or retract in the tunnel, and they have problems.
All right.
And so we have to have that discussion with them and make sure they still really want that. And from my language, I can tell that they were a little demanding, if you will.
Well, hey, there's nothing unusual about a mother and daughter being concerned about having this port stick out and be noticeable in a T-shirt or low-cut dress, not low-cut, but you know.
I mean, from your perspective, maybe, but it's actually very unusual for patients to specifically ask for a port to be placed somewhere.
Would these notes that we just went over, exhibits 1 through 4, would they be available online within the Johns Hopkins system so that if Maya and her mother came in later, another doctor, assuming it was necessary, could access these records and find out about this?
When I was there, this note would not have been available. I do not know if it is now. Her surgical records from the hospital would have been, but clinic notes were not available on the main system that I can recall.
And why would that be?
It was a separate paperwork system from the office to the hospital.
How much information would be in the surgical record?
You mean the surgery office or the hospital?
What kind of things could a Johns Hopkins physician pull up within their records to know a little bit about this surgery?
So as I recall, it would be the patient's H&P that's done by the nurse practitioner in the pre-op area, and their op note and their anesthesia record. That being said, this was a while ago, and computer systems are constantly changing and adding stuff, and I'm not sure now what's available versus what was available then.
That concludes the planning of the... Okay, members of the jury, we've just got one more minute before 5 o'clock. You want to call another witness? Okay. Do not discuss this case amongst yourselves. Do not do any investigation. Receive no information, and we'll see you tomorrow at the same time. Have them ready to go at 9 a.m.
All right.
All right, as the jury is leaving here, see if we have any paperwork to go over here with the judge before we end for the day. We'll tell you that tonight Rob's going to break this down. I've got a redirect on this live stream that will port you straight over to his channel, even though there's going to be a break between the two. It'll at least get you over there so you can click the like button first as soon as you land there, and then click the notify me when it goes live button as well.
The jury is out of our presence. Everyone can be seated. Did I overhear Ms. Crowell's say that you were taking all the time for that last doctor, or was there?
That last 16 minutes? Yes, correct.
So assuming that
means
was
that everything was
correct, I can tell you the plaintiffs consumed 1 hour, 30 minutes today and are now at a total of 51 hours. The defense consumed 2 hours, 55 minutes. And now stand at 26 hours, 45 minutes. I assume that's what you wanted to know.
What?
I assume that's what you all wanted to know.
Yes.
That is awful.
Do we have time to do the Alexander Depp, Judge?
Yes.
Issue?
I assume there were a couple things we had to do before we left today.
Okay.
They can't keep doing this. They have they have 8 hours left. 8 hours.
Judge, I'm actually not sure what their, I'm not quite sure what their objection is, but I understand from when we tried to put the records in. This is a doctor who was a resident at the time and took the history from Mrs. Kowalski that she was giving ketamine. And so I think the concern was...
This was done in the ER room, the ICU?
No, this was an admission. Is it an admission? ICU admission. At Arnold Palmer Hospital. Okay, so if I could direct the court's attention to page 74. I only gave you the pages that were going to be, that we had designated. Okay. So if you look at page 12, or line 12, it says, mother states that she has been doing ketamine injections through the patient's port at home of 50 milligrams up to 30 minutes PRN. Mother states the patient will occasionally go days without needing ketamine, but sometimes she needs it multiple times a day. That's what I relate to be by the mother. And then if you go to page 81.
When was this admission?
April 2016.
April, thank you. If you go to page 81, let's see. That's a question. Hold on, let me find the page 82. Sorry, in answering the question, because there's all this explanation of who said this and where'd you get it. The witness says on line 3, the way I documented this means that when we were speaking, we talked about getting the ketamine boosters every few weeks, as she does with Dr. Henna. However, I stated that she's been doing ketamine injections through the patient's port at home. And if you read on, I documented several things. I said ketamine injections, which means IV. I stated through the port, which means I was told through the port, and I say at home. So he reiterates that the mom was talking at home. And then on 136, again being asked about that statement, line 24, I say mother states, meaning mother is telling me that she has been doing ketamine injections, and then he goes on to explain what that means. There's no question, Judge, but that this is a party admission, if not medical history, and it is a statement that the doctor is testifying he was specifically told by Mrs. Kowalski, which he then documented in the medical record as mother states. So I'm not sure what the objection is at this point.
This is admission by a party opponent, so it gets around the hearsay rule.
He says it again on page 140, on
This would
line
be the
14.
first witness.
I say the mother states that she has been doing ketamine injections to the point. I specifically state it was the mother. So I'm not sure what the
This home injection has been
objection would be.
a point of contention. The plaintiff has fought very hard against this, and this witness is the most powerful testimony we've seen to date.
Were you finished, Ms. Quarles?
Yes.
The objection is relevance 403 and along the lines of what was discussed on Friday afternoon and this morning. This is a resident, and it all weighs into Chapter 39 issues. This is a resident who's not competent to give these opinions. His record also indicates that Maya had a normal gait during this admission at Arnold Palmer Hospital, so his records are completely unreliable. The prescriptions at the time were for IV ketamine at home. So it's confusion on the resident's part. And again, none of the supposed knowledge of this resident in April of 2016 was ever communicated to or made aware to Johns Hopkins Hospital in October of 2016. So it's irrelevant to the medical malpractice claim. It's not even relevant to an intentional infliction claim. It's not relevant to any pending claim in the lawsuit, and it's a 403 issue. The court on other occasions has refused to admit evidence that would be along the same lines as this. Those are our objections, Your Honor.
He also works for Johns Hopkins.
Oh, he now works for Johns Hopkins, by the way.
At the time.
And he joined them in 2017 and worked for them during this deposition.
Not sure the relevance of the last comments, Judge, but this clearly goes to credibility issues with the patient, with the plaintiffs. It goes to Mr. Kowalski's testimony that they would not be ejecting at home. I mean, it's a credibility issue that the plaintiffs are under anyway. It also goes to past medical history. It goes to several issues in the case.
Well, there's already testimony that for the Kowalski family, both Jack and Maya, if I remember correctly, that she was receiving ketamine at home orally.
Correct, but they specifically denied that there was any injections of ketamine done at home.
Just out of curiosity, though, other than, how is this not a collateral issue? Well, y'all love that safe word, don't you?
I'm sorry, it's not the microphone.
Yeah,
my apologies.
It's not collateral, Judge. It goes, again, to the jury's assessment of Mrs. Kowalski's state of mind. It goes to the Munchausen's concerns that are being raised. It's support of that. It's a impeachment of the plaintiffs directly involving their testimony with regard to what type of care that she was having at home. They just asked Dr. Elliott, don't they have the right to make these decisions? They're putting this issue in front of this jury. And the jury, I think, needs to understand, as part of their assessment of this case, what types of decisions were these parents making? And at this point, there's evidence that Mrs. Kowalski was, contrary to the testimony that's been presented to this jury, was in fact injecting ketamine into Maya.
And are there any records, prescriptions that were filled with IV ketamine?
Yeah, I can handle it. Do you mind if I handle that question, John?
Go for it.
Okay, yes, oral ketamine and IV ketamine can both be used in the same way, and this is why it goes to the heart of the case, is because when the Kowalskis came to All Children's, part of our medical team's concern was they weren't able to access some of the outside records. And as I rushed to the bench during one of the questions of Dr. Katzenstein with, when they're asking, does any of this show a dangerous practice, that the Kowalskis continued to inject into this litigation, that everything that they did on an outpatient basis with other doctors is safe. It was the whole theme with Dr. Elliott. What we did was safe, this was normal, you just weren't used to it. In fact, this goes right to the heart of the defense. For us to be able to say to this jury, we had concerns, they weren't turning over records, we had concerns with over the safety, and in fact, on both real-time and retrospective review, we're right. This is, respectfully, an extremely dangerous practice for a mother who's an infusion nurse with access to these supplies and access to ketamine and knowledge of how to access a port to be able to infuse an anesthetic on her daughter through the port. Now, if they want to cross-examine and say, what other evidence you have, it's not just this record. This is not an outlier. In this exact same time period, we have the admission through the note from Mr. Kowalski, who turned over his wife's diary that says she gave ketamine through a port. And we have Dr. Hanna 2 days after that record having Mrs. Kowalski sign a contract. So as the Kowalskis inject these things into the case, these are parents' rights. They get to do, you don't have a right to second guess it. This goes right to the defense of our case to be able to explain that there were things that raised red flags, including the refusal to give outside records, which show exactly this.
So where is the prescription for IV ketamine?
We have those records that we're willing to put in. We can put in evidence through quorum, including one of them that was filled by Mrs. Kowalski while Maya was in the hospital.
The prescriptions are for IV ketamine for oral use. They all say this. Right. And the testimony of the pharmacist is that this is the way that this has to be filled. It's IV ketamine for oral use. So it's intentional confusion by the defense. Can I respond to some other things we just said?
Yes.
Regarding, so this is a record from April 2016. So the assertion is, well, this was extremely dangerous for Maya Kowalski. The question of the defense is, where is the evidence of any harm from this alleged use by one resident at any time? This is around the time when Dr. Kreisman comments on how well this child is doing. There's no evidence between January and August of 2016 of any harm to this girl during the time that this resident alleges that there was IV ketamine going through the port at home. And then I have to address this rushing to the bench idea. Again, that question was specifically targeted at Dr. Katzenstein's diagnosis of psychological factors affecting other medical conditions. And the question was, with this diagnosis of psychological factors affecting other medical conditions with an underlying physical condition of CRPS, does not pose a danger to the child. Does it, Dr. Katzenstein? She said, no. That's nothing to do with a resident's opinion about ketamine and misunderstanding the prescription.
Judge, this goes to weight and credibility. It doesn't go to admissibility. This is a medical record, prior treatment. The predicate's been laid by the testimony of this doctor that he got it from Mrs. Kowalski. It's not a question of the source. It's an admission. Their arguments can all be made, but this is about admissibility, and this should be admitted.
Anything else, Mr. Whitney?
Reiterate the question, what claim would it go to? They didn't have no knowledge at the time.
Yeah. And none of those, there is no evidence in this record.
To Mr. Whitney.
Oh, sorry.
I still am concerned about the 403 issue in this particular case. And knowing for years this concept of she being Beata Kowalski used ketamine in her suicide, and the reality is Maya and Jack Kowalski already testified that she had ketamine at home orally, and I'm not seeing the huge prejudice here that you seem to be suggesting, that if we don't show that it was done via infusion versus orally, that somehow makes or breaks the case.
It is a significant fact, and just because I don't understand the court's reticence here. I really don't. Just because it's
for years I've been hearing about this and questions about suicide and mom using it, and
here, Judge, on this issue,
this
issue goes to their credibility. The Kowalskis took the stand and testified completely adverse to this. This is credible testimony. The doctor, although I want to say now works for us, the doctor is testifying as to what occurred with his interaction with Mrs. Kowalski. There's nothing to call into question this doctor's testimony.
The practical concern, and this is not a defense, this is a both plaintiff and defense. I feel like I give 1 inch
and then 4 or 5 feet later, I'm trying to rein everybody in. And so that's my concern, that given the history of this particular issue, and I know, Ms. Krause, you weren't part of the 2 years that I was dealing with this particular issue. I am really concerned that if I give 1 inch here, this is going to turn into something completely different. And that's based on lots of hearings on this particular issue.
I understand that, Judge. We've been through those hearings, and this is where we are now, and this is an issue in this case. And we're not going to start trying to say, and that means she used ketamine to kill herself. We've already stipulated that she committed suicide. We didn't even want anything in about the records about the suicide. Plaintiff's the one that put all that in. We were willing to say she committed suicide. They're the ones that wanted to put in all the records about it. And put in the picture of with the IV in her arm. They're the ones who put all that in.
I still maintain this is a 403 problem, and I'm going to exclude it.
Judge, can we make one last record?
They don't want to do this.
Sit down. I know it's very frustrating in the court, but again, as Mr. Hunter noted, they made 5 references in opening statement that we had no basis to suspect Munchausen, no basis to take the child away, despite the court telling them not to do this. These records go right to the heart of a healthcare provider's concern. Ketamine through an IV can be lethal if not properly managed. This is not about oral ketamine being taken with Gatorade that can cause some nausea and vomiting. This is exactly what our experts are going to come into this court and testify, that there is a valid concern for this. They have made their entire case about there was no valid concern for Munchausen's. You had no right to put it on the transfer codes. You had no right to blame these poor parents. This is among the 3 biggest pieces of evidence for the defense to be able to turn to this jury and say, we have the records that we can line up that show mom told a doctor as an admission against interest she was giving IV ketamine through a port. We have our own handwriting that says she was giving IV ketamine through a port. And 3 days after her own handwriting, Dr. Hanna makes her sign a contract. And to cut the defense off from being able to say that gives the plaintiff this unfettered license to have told this jury over 3 weeks that All Children's has no basis to accuse Munchausen, to suspect Munchausen. This is the evidence of it.
And I go back, I have already instructed this jury that Johns Hopkins All Children's Hospital had a reasonable basis for the DCF hotline call, and that the hospital is not responsible for that. It's going to be reiterated again in the subsequent. I continue to remind, we are not trying the Chapter 39 case. And as much as the last few days I feel like that's what the defense wants me to do, is to try the Chapter 39 case, I continue to believe that the 403 problem with respect to this evidence vastly outweighs whatever probative value it has for the defense. It's not coming in.
May I ask the court, is the jury going to get an instruction that the defense had a reasonable basis to put Munchausen by proxy as a suspicion on the transfer code?
Mr. Hunter looks back for his appeal attorney.
Their whole argument is we have no reasonable basis to put that, and that's why they refused transfer. And this all goes to the reasonable basis that the defense has in real time and in retrospect that would support that.
I continue to maintain my ruling. What's next?
Judge,
Question.
Okay.
A question regarding that. Just mechanically, Your Honor, if the court please.
All 3 of them have now chimed in on this.
Can the deposition that has been proffered that we wanted to play, is that a sufficient proffer, or do we have to haul this guy down here?
Well, I don't know what you mean. I mean, I am talking about the specific questions that Ms. Crowell's just went over that reference the statement against interest of Beata Kowalski saying something to the effect of, I administered ketamine via IV. I think that issue you have told me about. If there's something else that you were going to call this doctor for,
no, there's not.
Then I can't say that the proffer is complete. If that's the only reason why you're going to call this witness, then to me,
I think you have completed the proffer.
Okay. Do you just?
I do.
But, I mean, obviously, though, we have not heard all of the statements from the plaintiff's side as to why they would believe that he made a mistake. It's a he, right? Brandon made a mistake with respect to what he heard from Bill. But regardless, I don't need anything more on the IV ketamine issue at home.
I just wanted to talk schedule, Judge, and what the plan of action was.
I have something substantive to discuss, which is Dr. Crane is going to be testifying tomorrow, we're told. It's the defense expert, anesthesiologist, and pain management physician from Stanford. We filed at DIN 3497 on October 14th our motion to limit his testimony and exclude certain parts of his anticipated testimony. Based on court's previous rulings limiting our experts in the same fashion. We have from Dr. Crane and attached to that motion his report, which is 10 pages, and vast swaths of it are, if the court's previous line drawing exercise is to be consistent, not relevant to this lawsuit. So I don't know the best way to go about this. I think the defense probably recognizes that there's several portions of this that will not be discussed. So maybe we could ask for what it is he will be testifying to so that we can respond to see if there's any ruling the court needs to make.
I guess I'm not clear as to what it is you're asking me to do and rule on.
Well, okay. For example, under 766, as we've heard from the defense, this physician is an anesthesiologist and pain management physician. He has offered in his report standard of care opinions broadly.
Are you saying he is not qualified under the Med-Mal statute?
He's not qualified to offer standard of care opinions for the pediatricians, the hospitalists, the neuropsychologists, the psychiatrists, anyone outside of the pain management team at the hospital. There's other issues I'd like the court to address, but I'll give you a moment if you want me to stop.
Well, tell me what Dr. Crane is. He's a pain management doctor?
Pain management and physician and anesthesiologist.
If the court please, it goes beyond that. Dr. Crane is board certified in anesthesiology, pediatrics, pediatric anesthesiology, critical care medicine, and pain medicine. He is qualified by virtue of those board certifications to address pediatricians, critical care specialists, anesthesiologists, and pediatric anesthesiologists. Those are the ones he's going to be addressing. He is not going to be talking about standard of care for psychologists or psychiatrists, but he will be talking about standard of care for the rest of the specialists I just enunciated, much as he did without objection during his pre-suit affidavit that plaintiffs have been provided in addition to his 10-page report. He has testified at length regarding his view of the standard of care in his report and in his affidavit. He has also opined on the standard of care with respect to anesthesiologists, specifically doctors Cantu, Hanna, and Kirkpatrick. He is board certified in that specialty as well as the subspecialty of pediatric anesthesia and is qualified to do that. Plaintiffs have raised the issue of whether he has addressed the issue of causation. His report expressly addresses that question on page 8, where he states that one of plaintiff's experts, who has since been withdrawn, indicated that there was no harm caused to Maya by the ketamine. He expressly states that is incorrect, and then he goes on for a paragraph about the harm that was caused. Counsel is correct that he is not going to be addressing the report of child abuse and the basis upon which the child abuse was reported. His report, after all, is dated back in 2021, but we respectfully submit that this question has already been addressed in plaintiff's motion in limine their Daubert motion filed a while back here. If I can find the DIN number, Your Honor denied it on 3412. The DIN number for that previous motion is, now I can't find it, but the point is, not only has this already been hashed out, it's been considered by the court and denied, and Dr. Crane is fully competent to address the areas of standard of care that we intend to elicit testimony on with regard to him tomorrow. And I would also point out to the court that part of this is based upon the failure of plaintiff's counsel to conduct a deposition of Dr. Crane when they had it set to do so in this past June. So we respectfully suggest this should be denied, Judge. Their motion before was DIN 2496. It was styled at that point as a Daubert motion.
Your Honor, he just responded to arguments I hadn't yet made, so I've had an opportunity to respond.
Sure.
Just like the defense filed a Daubert motion and then converted it to a motion to limit the testimony, we're doing the same. In his report, he offers opinions on conversion disorder and functional neurological disorder. He's unqualified to do that. This Fabre notion, there's no causation opinion in this report. On page 8, there's no causation opinion. To a reasonable medical probability that doctors Cantu, Kirkpatrick, or Hannah caused any harm to this patient, the closest he gets is to say that the polymicrobial pneumonia, which is incorrect, it was a culture during intubation but never progressed to pneumonia, could have proven fatal. That's the closest he gets to a causation opinion. Nowhere in this report does he express causation opinion with the certainty he would need to testify against these physicians. I think appellate counsel of defense has recognized that the court's deficient by nearly stipulating that there would be no Fabre defense in this case. And then throughout, he also laces in.
I guess I'm trying to find the guy's report.
Oh, I'm sorry.
Where is? I'm looking at 3497.
Your Honor, I've got a copy of it here.
And this is
Exhibit H to our motion, I'm told.
I'm looking at something for Dr. Alexander.
Defense has taken a big loss today in not being able to bring in that information, that testimony about Beata reporting that she was giving ketamine intravenously at home.
Well, on the question of
that's what they wanted to be brought out.
Whether he would meet
big loss for them.
The qualifications under Chapter 766.102, or I should say Section 766.102, paren 5.
We're not challenging as to his specialties, under that basis. We're challenging to specialties he's not qualified in, such as psychology, psychiatry.
Well, and I think he just said that they weren't.
Okay, then there's no issue over that.
So then the next issue is that he being Dr. Crane is not making a statement to within a reasonable degree of medical probability
as to causation of harm caused by doctors Cantu, Kirkpatrick, Hannah. The criticism that defense counsel just mentioned was of a former expert of ours that has been dropped and was dropped long ago, Dr. Webster. So that can't get them over the hurdle there. And then the last issue is that he wants to comment on both the suicide and Chapter 39 duty to report issues.
You were talking about something on page 8.
The first full paragraph on page 8, Your Honor. And
that says he stated that ketamine?
Yes, he stated that ketamine caused no harm to Maya. That is incorrect. She contracted a polymicrobial pneumonia in Mexico as a complication of ketamine use that could have proven fatal. During her subsequent treatment, she was significantly underweight, probably as a consequence of appetite suppression by ketamine. In my opinion, she also became physically dependent on ketamine and experienced withdrawal symptoms. In my extensive experience with ketamine use as a treatment of pain in hospitalized children and as a sedative in children with intensive care, I can state categorically that children do exhibit physical dependence on ketamine, and withdrawal symptoms of ketamine is not tapered or weaned. Judge, he didn't say the magic words reasonable medical probability, but he certainly said that there were complications of ketamine use that he was criticizing that were probably the result of the ketamine use. I suggest that by Your Honor's previous statements about notice in the report, that nails it.
Well, to me, the question of notice, it's there. Did you all take a deposition of this doctor?
No, Your Honor.
Okay, so look, if he doesn't testify to a reasonable degree of medical probability, then it's going to be out. I mean, or you can't use it for any sort of Fabry. I don't even know if you're going there anymore.
I understand completely.
Yeah.
Phrase my questions accordingly.
So, I mean, the report is put you on notice. At least you're in the ballpark. So it's up to you to take the deposition.
Thank you.
What's next?
The other issue, I assume they'll agree he's not going to comment on the reasonable duty to report as he did in his report
That's
here.
out.
That is not an issue in the case.
He also, sorry, Judge, he also has an opinion that she did not really commit suicide.
That's not what he said, and he's not testifying about suicide.
Judge is done.
What's next?
As far as I'm concerned, Judge, there's also this issue with respect to Dr. Alexander. Dr. Alexander is not, I mean, we're not calling...
Different Alexander.
Yeah, different Alexander, sorry. Not the one you just ruled on. Another Alexander. We have another expert whose name is Alexander, who is a board-certified pediatrician. He's also board-certified in child abuse pediatrics. His principal purpose is to testify about general pediatrics, and once we get straightened out where we can go with it, what Dr. Smith did. The baseline of his opinion has to do, again, with child abuse pediatrics and Dr. Smith's involvement in the case, as well as standard of care for pediatricians. He's not testifying about Fabry issues or criticizing other doctors. He's just testifying about standard of practice, whether it was reasonable to suspect Munchausen by proxy, whether it was reasonable to suspect factitious disorder and conversion disorder in this patient, and he's qualified to do all the above. The counsel, I think, is also concerned about Dr. Kelly. I've told him he's not coming. There are not any other witnesses that I think we need to cover at this time.
Maybe. Why don't we rather than talk about that?
Maybe. Shapiro's like, wait, we got some others.
So I'm not sure what you're asking me to do.
I'm not asking you to do anything, Judge. I'm asking you to let us go home.
Let's second that. Let's rally.
Judge, I guess it would be then our motion. And the problem that we've got is exactly what the court has been dealing with over the whole weekend. They're going to try to drag this case back into a Chapter 39 debate about Munchausen by proxy for Beata Kowalski, as opposed to anything having to do with the treatment of Maya Kowalski. And the court's made that very clear, I think.
That's right.
So
Judge, can we talk exhibits?
No.
No. I don't mean deal with them right now. I just mean, what's the game plan? I don't think we added any yet.
Judge's
We're going
face
to
is
be adding
priceless.
some, but since it's past, we'll be doing it tonight, so we don't need to address any of them, I don't believe, for any of the witnesses tomorrow. But we're going to need some court's time with some exhibits.
Well, I think as far as exhibits, tomorrow morning I'm going to hopefully make rulings with respect to a whole bunch of those that we discussed on Friday.
Okay.
And then hopefully at some point tonight I will
return the Dr. Malik deposition designations.
Yeah, I don't think there's, have you filed?
And then I'll get to,
filed their objections? Yeah.
I'll also try to get to to Mr. Elegant and Mr. Altenburn the statement about the dependency orders.
Okay.
That's on my plate tonight.
Okay. What time would you like us here tomorrow?
Let's go with 8:30. And do you want this back?
Yes.
I wrote on it.
I'll take it back.
I only put lines. And do you want this back as well? I don't know who gave that to me.
I don't know what that is.
And we do appreciate all the hard work, even though we never say it.
I concur with Mr. Peterson.
Status is halfway out the door.
Have a good night, everybody.
Judge is still in the bench.
We'll be in recess.
Okay, there we go. All right, as they end. Oops. They shut off the audio, so we can't tell what's going on here, and the Zoom's done as well, so I can't hear anything. Mr. Anderson's gone. People are bailing. They're out the door. All right, couple things tomorrow. Yes, it's tomorrow. We are going to start at 8:15 in the morning. We start 15 minutes before court, just so we can, sing happy birthday to people and get everyone ready and sit down and ready for court. So that's going to happen first. Tonight, we've got a redirect set up. As soon as this live stream ends, it will redirect you over to Rob from Lawn Lumber, who has been in chat, just been amazing, just been overly generous to us, and I can't thank him enough for that. He does a legal breakdown because he's a lawyer and has got a lot of information on this. So he's going to break down what happened. I'm not sure. I think he's covering what happened today, maybe a little bit from before. I'm not sure about that. Don't quote me on that one. But you don't want to miss it. It's really good. The community over there is a lot like our community here. So if you like the vibe that's in chat, usually I say today got a little crazy. We had about 4,300 people. We had a few people come in that didn't know where they were, but other than that, it's a really nice vibe. It's a fun place to go, and it's very, very informative. And so I'd highly recommend that. We'll redirect you there as soon as we're done. Let's see. There's a couple other things. There's a few. Let me just quickly recap what happened today. Just a quick recap. So we started off. We had the discussion about the Munchausen by proxy. The discussion started on Friday with the judge asking the question of the defense. He asked Mr. Shapiro, what does it even matter if she had it or if she didn't? How does that change, the facts of the case with, how you treated Maya? Wouldn't this still just move forward? Does it matter if she had it or not? And Mr. Shapiro was like, well, we need to know if the plaintiff's going to argue this in closing, if they're going to wrap this Munchausen by proxy into all of their arguments, and no one wanted to say what they were going to do. So they continued the discussion tomorrow because Mr. Shapiro said on Friday, he said, because if they're not, then we don't have to, talk about any of this. We can skip all this and save all this time. Today, when Mr. Hunter got up and talked about this, he told a different story. He's like, this Munchausen by proxy is key to our case. We are basing everything on it. and that explains all of our actions and everything. So maybe Shapiro, when they rallied, got the lowdown from Mr. Hunter on that. Anyway, so that talk went down. Let's see. They had Dr. Elvin Mendez, who saw Maya back in 2015. This guy had an incredible memory. I'll say he had a very, very good memory. I'm not sure if he has a photographic memory, but when they said, do you have your notes? He said, yeah, they're in my head. I think he wasn't kidding. And he was able to recall and differentiate between first and second visit. And he'd do this little, flipping pages in his mind and then recount what happened. So that was impressive to me, even, let's see, even though he definitely did have he seemed to lean towards the hospital, like in who he's supporting. Let's see. He hesitated to answer what was covered in his first visit with Maya, which he was like, "What's your question? I don't understand." And he asked this several times when the question was very clear, even when it was short and a great question. He's like, I don't understand. Explain, elaborate on that for me, which seemed strange, but that was only under cross, and that's what triggered me just a tiny bit on as something's not right here. He also was the one who said that something did not add up. Things did not add up. Now he's an allergist and immunologist, and so he was looking in that area to see if that's what happened. He did look in the records and see that they had a lot of visits to other doctors and a lot of steroids had been prescribed. He's like, something's not right, might be Munchausen by proxy. That's where he jumped to, okay? And all he does is he sends a letter to the family physician, the main physician, and saying, hey, something's not right here. probably should have called if he really had that level of suspicion, but that's all that happened. Next one, we had Dr. Kastenstein, who's the pediatric nurse psychologist. Let's see. First thing, the thing that stood out to me on this one is when Mr. Shapiro, on like question number 2, turns to her and says, perhaps you can turn to the jury and explain. It's like, because first of all, she was very nervous, and she's looking right at Mr. Shapiro, like answering the questions. And he's like, this is for the jury's benefit. Remember how we talked to you about answer to the jury? So he had to redirect her. She did a great job. She did relax a lot and shared a lot of information. She talked about the pain scale and being a 10 on the 10. It should be the most significant pain she's ever had. She was offered the information from the blog by Beata to help her understand the injury. She turned it down. She did not want that. She says, I just like to make my own observations. She says the pain was real, but the symptoms are coming through deep psychological factors. The witness worked with Maya to help her stop tensing up prior to treatment in anticipation of pain. And then we had the conversation about the Ring movie through her, like that Maya saw the Ring movie in Mexico, and that's her biggest fear. They had the guided journaling that occurred. The pediatric neuropsychologist did the guided journaling with Maya, and I think that was the same book where she's like, here's my hospital stay, things that I like. I think that was basically what she was doing. She guided through this journaling. She was like, here, let's fill this out, let's answer this, and she was gathering information at the same time. It was in this type of setting, to my understanding, where they asked her about any possible SA incidents in her past, and she's like, well, a doctor came in and did this. And in the notes, this witness wrote, previously this occurred. And that's it. There was no follow-up. There was no chase this down and make sure this got taken care of. That was it. And it almost opened the door to SA. Turns out the judge says no. Mr. Shapiro was the one that elicited the question that brought it to that point, and it was a little bit scary as far as the trial goes moving forward, but we were able to avert it with a curative instruction from the judge saying disregard that everything about that, the question and the answer. Let's see. After lunch, the judge handled a couple of the DV issues that were still pending. Actually, all of them were pending, so we've got answers on everything. The remaining ones, charge number 5, the allegation number 5 about battery, specifically related to the EEG transport to that room. They said there was no evidence that was presented in trial, and there wasn't. The plaintiff has not presented any evidence that during that period, that transport to the EEG room, that she was grabbed or pulled or yanked off the bed or dragged unwillingly. There was no evidence of a battery that occurred there. So he granted as to that portion of the claim, and that means that the punitive that's attached to that as well was also granted. When it comes to 6C, 14C, and 18, he denied all. He said the plaintiffs made a prima facie case on those counts. And so 6C, I believe, is the, let me flip back here. 6C is negligent infliction of emotional distress, I believe. 14C is negligent training, supervision, and notification which involved doctors. I'm not sure exactly what the wording on that one was. And 18, denying all on 18. 18 was fraud, the medical billing, the fraud. So, but that's those ones. Everything else was denied. That you're going to talk about some jury instructions a little bit. We got a little bit of a notice that the judge wants. Mr. Altenbrand has been writing the jury instructions and prepping these instructions. He's like, look, I read through what I've shown you, and every other line in there says Johns Hopkins All Children's Hospital is not responsible for this. And he's like, you can't do that. You can't have this as every other line in the jury instructions. Maybe once at the beginning, that's about it. So they're going to have to rewrite those to make them a little bit more neutral instead of how they are currently worded. But it was a good effort by Mr. Altenbrand on that front. Okay. Let's see. We've got couple depots they were talking about. We had the third witness, Dr. Elliot Crane. He's the one that said that CPRS or functional neurological is the same as functional neurological disorder, at least the treatment's the same, and that treatment involves functional restoration. So it's physical therapy, getting them to move again, getting them to trust and try and make an attempt. And he says in doing that, they move first and then the pain reduces. And sometimes they can use pain medications to help treat that. But his whole approach to this is you just get them moving, get them walking again. And that's how he addressed it. Bulk of his testimony had to do with he was very much anti high doses of ketamine. That was it. See, we know we've got a Wednesday lunch meeting tomorrow, so we're going to break at 11:55 or 12 o'clock for the judge again tomorrow. Let's see. So I copied and pasted this comment. SW in chat says, it's my birthday. During our next break, would you perform a song like a poem word poetry reading, a spoken word poetry reading? Happy birthday to you. Happy birthday to you. Happy birthday, SW. Happy birthday to you. That's all I can do. Okay, so there you go, SW. We had Dr. Debbie Wallard, who's the doctor who placed the Maya's port. Now, this is an interesting testimony because it was a short. First of all, it was a 16-minute deposition played. That's the last one we had. It was very short. And why did the defense play this? I think it's because they want to say that the hospital, yes, the hospital placed the port. This doctor placed the port, but that has nothing to do with us endorsing the reason for the port, right? That was a doctor's order. They came to us with a doctor's order, and they're like, all right, doctor's order, we put the port in. It doesn't mean we condone and say, yep, we agree. And that's why she said, I just work here. I do my job, driving for an oil change. I change the oil. That's what we do. And then she didn't like the cosmetic reasons that the family gave for where they wanted the port placed, and said, no, that's very rare. And so she notated that in the notes. Big issue today is that once again, the plaintiff has used over an hour, and this time I think they used an hour and a half of their very, very little remaining time. They only have 59 hours total. And they used an hour and a half today, so now they're up to 51 hours that they have used. They have 8 hours exactly, and more than a week of trial left. They have to, as Rob pointed in chat, they have to start passing on crossing witnesses. That means the defense is going to put witnesses on the stand. They're going to say something that clearly they could cross and get them in a punch, and they have to say, nope, I'm going to pass on that. They have to look at this and just say, we're going to pick our battles from here on out. But an hour and a half was just unacceptable today. The defense has used 26 hours and 45 minutes, so they're right about the halfway mark or approaching the halfway mark. It seems they have plenty of time, at least right now. Tomorrow, judge is going to rule on a bunch of exhibits about some stuff that's coming in, and they're going to start in court at 8:30, which means we start at 8:15. So I think that recaps where we were today. I cannot wait to hear Rob's analysis of some of the more legal issues that are happening today and the things that happened, and the importance of them in this trial and how it moves forward. Because a lot of these decisions, as we watched today, we talked about the minefield, about how the defense was, with all the motions they've had, with all the rulings the judge has made, that it's a tightrope you have to walk, and you're tiptoeing through the minefield, and that minefield becomes more cluttered as court continues. Right, there are more rulings, there are more restrictions, there's more issues to weigh. And then the defense is now finding they have to walk through the same area, and it's very difficult. And today, Mr. Shapiro just about stepped in it, just about caused a big problem for them. And I think they're going to see that again. They have to be very, very cautious of that, because Mr. Anderson was on the spot. He had that objection, immediately as soon as they asked that question, got that answer. So that was good. All right, tomorrow we have Dr. G from Dr. G Explains. He's going to be on tomorrow night, and he's a clinical and a forensic psychologist, and he's going to be analyzing and telling us a little bit about what he sees when we watch the two depositions of Sally Smith and Catherine Beatty. So we're going to be watching those with him. He will be on live, so if you want to ask questions, I'm sure he's going to be willing to answer questions for you as well. So be mindful of that. But that will happen after court ends for the day. We're going to break just for a break. We'll come on. We'll be on. I think we'll be on StreamYard for that, and we'll be able to have a little chat. And thank you, Rob. Rob has said that he's going to hold off on his recap tomorrow night, just so it doesn't interfere with that, just so we can watch that. And I appreciate that, Rob. That is super generous of you. Thank you so much. Anything else we need to cover, or can we wrap up for the day and get ready for Rob? I think that's it. I think that's everything. Thank you, everybody who's been here. This is so much fun watching True Crime with you guys. This is the best community on the internet, and it is because of you. It would not be the same without you. Thank you so much for being here. Thank you to our amazing mods. I cannot tell you the amount of work they do, it's more than just the times they answer a question in chat. They are working nonstop behind the scenes, and they oftentimes don't get anywhere near the credit they deserve. I could not do this without them. Thank you so much, all of them. It can get stressful, especially when it's very crowded in chat today. We had a great crowd here today, and we love it, but at the same time, it's just a ton of work. So a big shout out and thank you to all of my mods. Thank you so much. That being said, we are going to wrap up tonight with music like we normally do. All right. This is like my Zen music. This is like, here we go. So, yes, more is coming tomorrow. It's going to be fun. It's going to be amazing. Does everyone feel better now? Deep breath. Deep breath. All right, tonight when you go home, please hug the people you love. Smile at someone, make their day better. And please, please stay safe. Make their day a little bit better. And please stay safe till we go live tomorrow morning at 8:15. I can't wait to see you guys over on Rob's channel at Law and Lumber. That's going to be great. Thank you to all those who came over from his channel. It is so great to meet all of you and see you in chat. Rob's amazing, and I can't thank him enough. All right, have a good night. Be good to each other. We'll see you guys tomorrow. Bye-bye.